Okay, good afternoon. We now have a quorum and we'll begin the closing the Justice Gap Scope Subcommittee meeting. This meeting is being recorded, and with permission of the chair, our co-chairs, I will start with the roll call.
Please do.
Tom Green.
Yes, here.
Becky Sandifer.
Present.
Marta Alkenbrock. Judge Irma Asbury. David Engstrom. Micah Star Liberty. Kevin Moore.
Here.
Toby Rothschild.
Here.
Patricia Scutiero.
Present.
Thank you. And I guess the next portion of the agenda is a public comment. So if there's any members of the public that would like to give comment, please use the raise hand function and we'll call on you. You'll be given 2 minutes to speak. Okay, we'll start with Tom Gordon. Tom, are you with us?
Yes, I am. Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working on behalf of consumers of legal services for a more accessible and affordable legal system. I submitted a letter to the subcommittee earlier, and I just wanted to emphasize a few points. I have a 7-year-old daughter, and she's really smart, but she's not as knowledgeable about, say, personal finance and household economics as some adults are. So when she wants to say, why we can't buy a new car, I tell her we can't afford it. And her response is often, can we put it on our credit card? There's 2 types of not being able to afford something. There's having to put it on the credit card, and then there's not even having a credit card. But both of them mean you can't afford it. And that's the difference between the 2 conceptions of the justice gap that I think we're dealing with here. Our written comments outline in great detail how big this gap is, but it also raises the question of why we're considering imposing a scope restriction on the sandbox that doesn't apply to the existing model of legal services. So if we were regulating the current legal services model from the start, we'd ask if it has closed the justice gap. And I think it's safe to say when the average consumer lawyer costs hundreds of dollars an hour, that the answer is no. So should we therefore not allow lawyers to serve clients in the current model because they fail to serve the indigent? Or why don't we have our licensing of lawyers be contingent on mandatory support for improved legal access, whether it's through pro bono or a tax on revenue or profits? So on the note of double standards, though, it's also a question to look at whether the reason for the current restrictions on the legal services business model is if you're restricting scope of services from Sandbox applicants to the poorest Californians because you're worried about consumer protection aspects of these rules, then why do we only say that the least protected among us would not need these consumer protection models? So we urge the subcommittee to refrain from putting in place these restrictions on the scope of services from the Sandbox participants that would keep this disparity between those who can't afford things and those who can afford it, but only at 18% financing a month in place. Thank you.
Thank you.
Is there anybody else from the public that would like to give public comment? Please use the raise hand function. It appears that's it. We can continue with the rest of the agenda.
Great.
We don't have any announcements, do we?
I don't think we do. Does the staff have any announcements that we need to make?
Just very quickly, because these meetings are coming pretty consistently in rapid succession, I want to just give a quick heads up to the members of the working group who are on this Zoom webinar that for the September 17th meeting, we have planned a presentation from a representative for the Arizona Alternative Business Structures Regulation System. So you should come prepared with any questions you have about the Arizona system and their re-regulation, so to speak, of the 5.4 standard. And another thing that's coming up quickly, this was announced by Justice Tucker a couple of meetings ago, but we will be having the 4 presentations from the 2-member teams, working group members on what are essentially ancillary rule revision assignments that are on the charter. So another one where if you wanted to come prepared, you would think about the questions you have about the non-legal services rule, model rule 5.7, the regulation of certified lawyer referral service programs, the advertising and solicitation rules of professional conduct, and as Adels put it, a continued consideration of amendments to rule 5.4, the fee sharing non-lawyer ownership rule that would be considered on a separate track from any sandbox exploration. So that's all coming up for September. Look forward to it. Thanks.
Great, thank you. And is there anything that's separate and apart, Randy, for a staff report, or announcements is sufficient?
That's it for now.
Okay, perfect. Let's turn to the approval of the open session action summary. I think looks fine to me, but I think I need a motion in a second.
Move to approve.
Thank
All
you,
right,
Toby.
excellent. Second was whom?
I'll second it.
Thank you,
Kevin.
Kevin. All right, we'll take a vote. Tom Green,
Yes.
Becky Sandifer,
Yes.
Marta Alkenbrock, Judge Irma Asbury, David Engstrom, Micah Star Liberty, Kevin Moore,
Approved.
Toby Rothschild,
Approve.
Patricia Scutiero.
Yes, approved.
Thank you.
Great. So the first item up in the agenda is a discussion of possible action on the draft Sandbox application, which has been distributed. So Professor Sandifer, Becky will take over from here.
Let's not be really formal. That makes Tom my brother attorney. Is that what they call them? So I just want to say a little bit about
My learned friend is kind of what you go for, but
just a bit about the agenda overall. So you may have noticed that it is ambitious, but this is an ambitious group, and so I hope that we can get through it. And there are some things that we really are hoping that we can push to the full group meeting that's going to happen on the 17th. And one of them would be a draft of the application. So we would say we recommend that this is the application as far as we can take it at this point. Another would be a recommendation about who the authorized persons are, whose moral character are assessed in the way that we decide. Another might be some kind of recommendation about the way David puts it in his memo is leveling up and leveling down. And the third thing might be some, not text, but substantive recommendations about what this group thinks the scope in terms of who's in and who's out of the sandbox should be. So if that's like the hugely ambitious agenda, but certainly we want to send some of these things forward to the full group in a couple of weeks to make that work go forward. So in terms of the application, I think that this group has been over it a number of times. One way we do this is, as you went over it for the 99th time in preparation for this meeting, were there things that you thought were missing? Were there things that you thought we should approach differently?
The only point I will make, it's on page 2, questions 1.2 and 1.3. I shouldn't say it's the only thing. I'm sure there'll be other things. I made a number of notes, but the thing is, we refer to controlling persons and financing persons. How are they different from authorized persons? I mean, it seems there's a bit of redundancy baked into the application as it's currently drafted. I don't have a problem with that, but I'm just wondering what the thought is, why we have done that.
it might make sense for me to field that, Becky. So what we're going to do, I think I was reacting, I think, primarily to Justice Tucker. When you look a little deeper into the materials, there's a proposed draft definition of authorized persons, which ultimately includes all of those people under the definition of authorized person. So that at the end of the day, this should be accurate. It will be authorized person, but that definition is now laid out in more detail that would cover compliance person, compliance attorney, if that's what we ultimately decided to do. And it also includes folks that have a supervisorial role of supervising 5 folks or more. So I think hopefully we've cleaned this part up. At least that was our goal.
Okay, you also mentioned on page 2 as part of 1.1, the reference to registered agent for service of process. Is that something that you want to?
So I think that's an open, yeah,
It's an open
whether we
question.
want that information or not.
Yeah, I think getting that name is useful, but I think the real policy, we do need somebody who's a registered agent for purpose of service, certainly, but that person, at least in my judgment, should not necessarily go through any kind of vetting. I mean, it's really a ministerial sort of activity.
Yeah.
So authorized person goes to the folks who have control or supervisorial relationships to the Sandbox applicant, and those would go through, they would have to make disclosures and it would be subject to review by the Sandbox regulatory structure.
Okay, because if it's an entity corporation, it'll have an authorized representative for service of process.
Yes.
Correct.
That would be
Right.
that would be our sense of what we need to do here. Yeah.
But we wouldn't necessarily be asking that question, not just that person, but it's the contact person that for the Sandbox regulators. Is that what we're asking for? Who is the contact person and their contact information?
Yeah, I mean, basically what we did was, if you go back to this additional language, which I think is 2B in the packet, the term compliance lawyer, this is as you recall, an importation of what's done in Arizona. And there's an indication the compliance lawyer, as defined, may be designated by the Sandbox regulator as the person responsible for promptly responding to requests from the Sandbox regulator to the Sandbox entity for documents and other information. It could be the same person. It doesn't have to be.
You know, it seems to me that agent for service of process is really a term of art.
Yeah.
I'm not sure we need that at the application stage. It seems to me that
No.
prior to being operational, we would probably need that. But I don't know that we need to know who the registered agent is at the time where they're applying.
I'm okay with that. Do others disagree? I mean, at some point you do need somebody who is there to accept service if necessary, and you bring these folks into the jurisdiction of the courts here in California. But I don't know that they need to disclose it. Those are two distinct things.
Could we maybe in the definition of compliance lawyer fold into the compliance lawyer? That's one of the compliance lawyer's functions, is to agree to accept service of process.
I think that would be a practical solution. One little footnote on that, though. We as a group have not decided that there would be such a person as a compliance lawyer. We've not adopted the Arizona model. So I think that we could certainly indicate that that could be a role. That makes completely good sense to me. But
Okay.
all right.
Thank you.
Mimi, I think we just accepted a friendly amendment. Do we need to vote on this, or what's your sense?
I think this is still being discussed, so I think it's fine. We leave it as this until we finalize the rest of the document. I mean,
Okay.
If I could answer your question, if there's no disagreement on this sentence, then you don't need to take a vote on it, and you can vote on whatever final decision is made at the end.
Okay,
Does that
perfect.
make sense?
Yeah, no, that makes completely good sense. That's a
Okay.
much
If
more
there was
efficient way
division
to
amongst the
proceed.
group, yeah, you might want to take a vote, but it seems as unobjectable, so you continue to proceed.
also, you may want to wait to take votes on things. And I'm just suggesting this, but you may want to wait until we have more people.
Yeah, great point.
Do we know if others are coming?
Yes.
Yeah, David Engstrom should be here about 12:45. And I believe we've got our new judicial member coming in at 1 p.m. Mimi, is that correct?
She said she doesn't know what time her mediation will conclude, so there's a possibility that she may not attend.
Okay. So Becky, back to you in terms of going further through this application form.
So were there other, thanks Kevin for those points. Were there other things that that folks feel that we need to have further discussion about, or that we need to add, or that we can drop at this stage when we're collecting information about admission?
I would like to mention one thing with respect to, there's new text under 4.1. So this is where the applicant has to fully and candidly discuss any risks associated with the product that they want to offer to California consumers. So 2 changes, and then something got lost in the shuffle here. So I added a including but not limited to, that is, there might be a list of things here. That was the contemplation that we'd want to call out that we're particularly interested in. And I inserted some language here that tried to deal with, you know, the thing actually works technically, and it's not unfair or discriminatory, trying to get at the dark pattern set of issues we talked about last time. But so there's that new text. And then in the prior draft, underneath it was a statement that additional points would be added in response to the work of both the SAGE and SCOPE subcommittees. I think that should go back in, but other than that, I think I'm good to go on this one.
I had some text issues, but I don't want to burden us with those right now. I can send you separately, you know, some nits and so forth. But on 2.4, I did have a question where you said, describe the entity business model you want authorized in the sandbox, including the management structure that, and then it says oversee direct. Should that be oversee or direct, or oversee / direct? They mean 2 different things to me. And when
I see what you're saying.
Yeah, when you use direct, when we're talking about independent judgment of lawyers, I just want to note that in the Arizona application where they have ABS, they say that regardless of who might own it, the lawyers who are working in the entity still have to comply with the rules of professional conduct. And although Arizona wiped out its Rule 5.4, which is intended to protect a lawyer's independent professional judgment,
Right.
The actual rule that imposes that duty is Rule 2.1, which Arizona still has. So, you know, when we use the word direct, that's kind of a loaded issue.
I think there may be another way to read that, and it may just be a way we're reading it. I think that direct there applies to services. So it's who oversees the direct service provision. That is the providing of direct services to clients.
Oh, it's not a verb. It's an adjective.
An adjective is the way I read it.
Oh, I see.
Kevin, does that work?
Or if we want to get into a discussion, is it an adverb?
Right.
Yeah, well, point well taken.
We could spend the next half hour on that.
Which is why I'm going to call on Randy, who has raised his hand.
So under section 2.1, I'm wondering if it might be helpful to have some checkboxes there. And the kinds of checkboxes I was thinking about are checkboxes for things like unbundling / limited scope services, services provided on a subscription or membership basis, services offered for fixed fee or on a sliding scale, or payment schedules. And the reason I mention this is because the Office of Professional Competence also administers the lawyer referral service program. And by statute, a certified lawyer referral service must offer separate services to assist consumers of modest means limited means. And in our application for the lawyer referral service applicants, we actually include check boxes. And so if we need to, for example, explore how many current certified programs offer limited scope services or subscription or membership services or services on fixed fees or sliding scales, we can go through the applications and we can gather that data pretty readily. I'm wondering if it might be helpful at the application stage to also be able to, on a simple checkbox basis, be able to identify those Sandbox applicants who are offering limited scope services or membership or subscription or services on fixed or sliding or on payment schedule, so that if we have to, report to the board or get media inquiries, we can say, 50% of the applicants are offering limited scope services. Again, it's just a suggestion and based on our experience in administering the lawyer referral service program.
Yeah, I mean, I personally am not averse to that, frankly, but the sort of the attraction in the current 2.1, I think where I probably arc to on the natural, Randy, would be maybe check boxes plus this, because we're asking them to describe what they want to do. So I think having them not be bound by check boxes.
Oh no, I wouldn't eliminate the open question.
Oh, okay. So
I think this is a supplement for those that,
Okay.
and maybe we haven't discussed scope yet, but in a way, it also might be a gentle nudge to the applicant in terms of things that would be good to do. But I wouldn't change what you have there. I would just add the check boxes.
So Randy, would you accept this as a friendly amendment? Since we don't know what the scope is yet, could we make those check boxes in this question about services to people of modest means yellow? So that, right, it's sort of issues
Absolutely,
that we'll resolve
yes.
once we,
Absolutely.
Yeah, and the rest of the group, what do you guys think? Any strong opposition to putting it in the yellow category for what we send on?
And actually, I don't even think we have to frame it as to people of modest means. It can just be, these are certain types of strategies for delivering legal services. And we're just interested if you're going to be using those strategies. They're pretty common. Limited scope is now codified, if you will, in the rules of professional conduct. They never was, but I don't think you have to actually align it with this concept of people of any particular category. Just these are things that providers do in California, and we're just wondering if you're going to do any of these too.
Yeah. Yeah, I think in terms of the text that Mimi's typing out, it may just make sense to, because that first sentence, I don't, we're scrivening again. I don't want us to limit what can be offered. So I think I just say, please check any of the following that apply, and then just there be the boxes, whatever they happen to be.
Yeah, I think that works. And since it's in yellow, we can always come back and scriven it. I'm glad you guys are interested in including this concept.
Yeah, I mean, I think I could live. It's the first sentence that's problematic for me. So if you could strike that first sentence in yellow, then just say, which of the following will your service offer? Check all that apply. Then we'll insert your boxes.
Maybe which, if any.
Which, if any, yeah.
Even better.
Yeah. Okay. If any, after which, yeah. All right. Okay.
All right. So this is great. Other issues folks want to raise with the current draft of the application?
So just to.
Could I had one other suggestion. I apologize on question 3 on page 4. This is the one, why is your proposal eligible to enter the sandbox? And I'm wondering if it would be helpful here to give some examples. For example, it's a non-lawyership of an entity, which is currently prohibited by 5.4. Fee sharing with non-lawyers prohibited by 5.4A. These are just, do you propose, and I don't even know if this is something that we even want to go there, whether you want to do it, but there would be an advance payment of costs. Right now, our rule 1.8.5 prohibits the lawyer before the lawyer-client relationship is entered into, offering to loan any money to a client. You're trying to even the playing field so that lawyers cannot go out and have an advantage in attracting clients if they have, say, a particularly good case. So I'm not sure we would want to change that, but you know, those are the types of things that we might want to include. You know, I've only came up with a few examples, most of which are related to Rule 5.4, but I could come up with others if folks think that might be a good idea. It doesn't have to be an exclusive list, just a for example list that we would like you to explain to us why. And
So Kevin, this is another kind of friendly amendment, but also a question to sort of understand the thing you're offering. So what the examples would be, I think, would again be contingent on what who can we decide is in and out. So that would be something. So the specific content of the examples, I think, is on hold until we have that conversation. But could you say a little bit about you know, what you want examples to do in this instance?
just to give them an example, because you might have some folks who are coming in and they might not be as intricately familiar with the rules of professional conduct as the people sitting around this Zoom screen are right now. And so, you know, just give them a little prod. This is what we're looking for, as opposed to you giving us some kind of a non-responsive answer. You know, if we will, maybe we don't want specificity. You know, they're just saying, well, I'm a non-lawyer and I want some ownership. I want to earn some of the profits. Maybe that's all they want to say. Maybe that's all you want to gather. Or do we want them to actually think it through before they come to us? Because essentially they would be telling us what rules they want us to suspend, at least in part, within the sandbox for them to be able to advance their business model.
Yeah, if I can be recognized, Becky, I kind of think this might be helpful, but I think I would do this as a footnote so you can actually sort of explain it a bit, you know. Examples may include and do that. I think I would think about that. But
Yeah, I didn't know about the advanced costs ability for the lawyers to be able to do that. So I think that some sort of example would be helpful as well. A footnote or however.
yeah.
Yeah, well, I'm a law professor. I like footnotes, so I'm fine with passage.
So are folks okay with this?
Yeah.
And then the specific content we'll figure out once we know what the specific content is.
Yeah, and I think maybe we're going to be discussing what rules, yeah, are not going to be subject to suspension. And you know, I gave the 1.8.5 as an example. You know, like offering a loan before the relationship has been established.
All right, great, thank you. Other things modifications we want to make to this draft?
I think we're good. Shall we approve it as with all the various suggestions, and we do have some additional language coming in from, particularly from Kevin.
So do folks feel like we're in a place where we can say this group is going to vote on recommending this as the basic content of the draft application to the broader group at its meeting on September 17th?
So moved.
Second.
Right. One question in the, so does this, I'm assuming it does, but just confirm that the draft definition of authorized person is now part of this puppy?
I think that's a second.
So that's
we've
the
made that
next
part of
piece
this
on the
agenda.
agenda.
Yeah.
Okay,
Yeah,
that would
that
be
should
fine.
be.
Okay.
So should we discuss? Okay, parliamentarians, should we discuss that first?
I think if you can envision that discussion going pretty smoothly and having it encompassed within the vote on the application, then the action that's recorded that goes forward to the full working group is really just that vote. So if that's the optimistic outlook, then I would say let's talk about it and take a single vote.
All right. So I'm going to bounce that to Tom.
Okay. So turn to 2B, it says draft definition of authorized person. So at least the aspiration here was to expand authorized person to include the folks we think need to make disclosures and then would be subject to review by the entity staff. So in essence, what's happened here is authorized person is expanded to include a compliance lawyer, assuming one is required. And then secondarily, the definition, if you go down just a little bit, Mimi, of decision-making authority, which is one of the key things in the authorized person definition, this would include a new subdivision, 5 little i's, which is supervision of 5 or more persons providing Sandbox entity services directly to consumers. So the idea here is the actual language that we borrowed from Arizona really talks about people that own things, people that are in the control group, you know, the CEO or the equivalent, the board, et cetera. And this now includes not only folks that do high-level corporation or firm-wide policy judgments, but includes folks that are supervisors of the people who are actually providing services. So those are the 2 little wrinkles that were added. And on the last, you might want to look at the 5 or more. I kind of focused on, you know, what is likely kind of be an ordinary span of control for supervision. 5 or 6 is typically the number. So that be the proposed definition of authorized person. The effect of that, when you filter that through the earlier language, is that would require disclosure from these folks, and presumably they would also be vetted by the entity staff.
And I assume then that there would be an ongoing duty on the Sandbox entity to notify and allow vetting of anyone who assumes one of those positions after the initial opening. So example, if at the beginning, they don't have anybody supervising 5 people, but once they start hiring up, they do, that new supervisor would then be included and would be disclosed and would go through the vetting.
That would certainly be reasonable from my perspective. I'm not sure we need to put it into here for the application, but that certainly would be my sense. I think of that as more of a SAGE issue, but you know.
Let me just quickly comment on that I think even though we're voting, quote unquote, on the application, there will be some framing elements, some boilerplate things that will go into the application so that it's consistent, I think, with how other state bar applications are constructed. And so there'll probably be things like when you sign to submit it, it would be accompanied by an attestation that everything is true and correct under penalty of perjury. And there would be something that would says the person submitting it acknowledges that they have a duty to promptly advise the regulator of any changes in the information submitted, and that they have read and agree, understand and agree to be bound by the program rules. So I think all those boilerplate things will be added and would cover things that like what Toby just mentioned.
Okay. Yeah, I mean, it makes sense that we would have those kinds of ongoing requirements, or, you know, yeah, that makes sense.
Could I make just one suggestion on the number?
Sure.
I don't have any great dispute with the number, but I'd like to get some insights from Utah, because I think some of their proposals don't involve a very large entity. They're smaller entities, and the 5 or more might not capture information that we might want. So I would just put 5 or more in brackets, or just put 5 in brackets until we just get some information, perhaps from John Lund, as to the size of the entities that have been applying and been approved in Utah.
Yeah, I mean, I'm certainly not averse to that, but if it's thinking this through, though, that I assume that if, for example, this entity is 4 people, the supervisorial activities will be captured by folks that are covered in other parts of this definition. But it can't hurt to keep that as a, you know, something to talk about. So I'm open. I'm okay with that. With those suggested changes, are we good to go on this as an addition to the application?
I am.
Okay. Do we have a second?
Sure.
I take that as a motion, Toby.
I
Sure.
think we already had a motion previously, so are we withdrawing the previous motion, which was to approve the application?
Oh, okay. Then this will be, this is an addition. So, okay. So with this addition, with the changes we've discussed.
Neil has a point to make.
Yeah, Neil,
All
go.
right. I'm not saying make this change now, but you, and maybe David Engstrom would have some thoughts about this, but on the application 2.6 consumer data, you could craft that to include screening questions about whether the California Consumer Privacy Act applies. And that would be helpful to the regulator, because then the regulator would know, okay, it does apply. And if it doesn't apply, then it gives the chance for the regulator to sort of ask more detailed questions about how the applicant plans to protect consumer data. So I don't know if you folks remember, I think David wrote a memo.
Yeah, no, we're gonna be talking about that today, but I think,
yeah,
I think that would actually help. I mean, at least I know enough about the CCPA to be slightly dangerous. The real issue there is going to be whether you're large enough to be covered, because you have to be a pretty big entity. So it's going to be pretty obvious, I think, but you know, it can't hurt to ask that question.
Yeah. Mm-hmm.
Puts the question in their mind.
Right.
Yeah, for sure.
Well, is the regulatory entity of the Sandbox precluded from imposing those kinds of regulations similar to CCPA?
Another question, yeah.
Well, I think that's going to be a question we'll be talking about with the folks that wrote that memo. The proposal that you're going to be reviewing later in the day actually imposes it as a contractual obligation. So the Sandbox entity would be required to accept that as a condition of coming into the Sandbox. Whether that's adequate or whether we need to ask the legislature to change the CCPA to include that obligation, that's an issue that we're going to be chatting about a bit later in the day, I think. Okay. But it's a great question.
So then is this something that we put on pause to revisit once we have that policy decision kind of
I think so.
resolved, or? Okay.
Yeah, actually, I think if they're big enough to have that statute apply, it would be interesting to know. I think you don't need to do that, actually.
So you mean unhighlight?
All right. So this is the state of play that we have a motion and a second for approval of the application with the various changes we've talked about.
And is this motion going to include the draft definition document as well?
Yeah, I assume
Yeah.
yes. Yeah.
I think I made the motion. I accept that as a friendly amendment.
Okay.
And
And-
Excellent.
I accept it.
Okay, good.
Okay. So you got a first and second. Okay. Over
Hold on
to
one
you,
second.
Becky.
So then, if we're voting, I think we have to do a roll call, don't we?
Yes, we do. So the motion is to approve the draft application as revised during the meeting, including the draft definition of authorized person to be submitted to the working group for consideration. Okay. Tom Green,
Aye.
Becky Sandifer,
Approve.
Marta Alkenbrock, Judge Irma Asbury, David Engstrom, Micah Star Liberty, Kevin Moore,
Yes.
Toby Rothschild,
Yes.
Patricia Scutiero.
Yes.
Thank you.
All right, that was awesome. We have a draft application.
Yes, yes. I'm
Subject to
doing the
election.
happy dance here in San Francisco. So anyway.
Okay, Tom, it's your turn.
Okay, so this one is an easy one, C. So we need a couple of volunteers. I'm looking at you. To sort of take on the obligation. We're going to need to have pros for the ultimate report on this question of, limits on the participation of disbarred lawyers, et cetera, which we have. The nomenclature we've used is ineligible persons to participate in the sandbox. So I'm looking for volunteers who would be willing to write up, a portion of the report on this particular topic.
Tom, while they're thinking, maybe I could just jump in and say that what you're seeing here is an example of something that will be an ongoing process that the leadership team talked about, that after the full working group votes on a discrete recommendation, before the memory fades about how we reach that decision, it would go quickly back to the subcommittee from where it came so that it could be assigned out to be drafted up for the report. And so,
I can't put the arm on Toby and Andrew today.
Well, I think it's completely fine to invite them to volunteer. But, we have other folks that we can rely on as well, but they would be the natural choice. And if anybody on the subcommittee has ideas for what would be the most persuasive arguments for this recommendation, either something noted during the full working group or was in their own mind, then this is the time to share that so that the drafting folks can get it all down in paper, and these things will be created as the progress continues on the working group.
Okay. I think that works for me. So I won't put the formal arm on Toby and or Andrew, but just think good thoughts about helping out with the drafting here. So based on Randy's good counsel.
And I'll be happy to apply peer pressure to both.
As long as it's those guys. Yeah. Okay.
Yeah, I'll be glad to take another crack at it with
All right.
Andrew.
Good on you too.
Wait,
yeah.
So a couple of things. David is apparently trapped in some kind of interstitial zone and cannot get in. So if someone could reach out to him.
Oh,
and
I
save
promoted
him.
him to panelist.
Oh, great. Thank you. And then I wanted to go back to B. Did we ever formally decide that those authorized persons were the people who got the background check? I mean, that's the sense of the conversation, but is that something we have to like resolve?
Good question. I think I thought that flowed from the authorized person the authorized person obligations.
I mean, if it's resolved, that's awesome. I just want to make sure it is.
That was certainly the intent that we had talked
Yeah. That's too important to leave hanging. Darn.
Do you need a separate motion, or would you
Yeah,
invite a
why don't
separate motion
I
for
think
that?
that may be the safest. Would you mind making that, Kevin?
The motion, as I understand it, is that those folks who we define as authorized person will submit to a background check. Is that
Shall make
Essentially-
disclosures and be subject to a background check by
Right.
the regulator.
yes?
Is there a second?
Second.
Okay. Any discussion? Going once, going
Just quickly for clarification, I think sort of assumed here is that the applicant actually has such persons. I think there was mention of maybe there could be a very small
yeah, it might be a
proposal.
null set. Yeah.
Yeah, so it's really, if they have it, then they are covered and they would have to submit.
I think that's the right understanding. So unless there's further discussion, and with that understanding, shall we just switch to a vote?
So the motion is that an authorized person will make disclosures and submit to a background check.
Yep.
Okay. Tom Green,
Aye.
Becky Sandifer,
Yes.
Marta Alkenbrock, Judge Irma Asbury, David Engstrom,
Yes.
Micah Star Liberty, Kevin Moore,
Yes,
Toby Rothschild,
Yes.
Patricia Scutiero.
Yes.
Thank you.
Okay, thanks, guys. And then I think next up is this really interesting set of issues with respect to confidentiality and privilege. And David has arrived. So David, do you want to take at least the initial laboring oar to describe this? And if you, with Kevin, could make some suggestions in terms of, what you think. I mean, they're just for everybody's reference, at the very end of their memo, it says possible approaches, and some of these just look great to me. So if you two would suggest what you think the right set of or right combination of initiatives in this space would be appropriate, that would be terrific. So David, to you initially, and then if you could hand off to Kevin.
Sure. So I think I kind of motivated this at the end of our last meeting together. And the basic problem, as you know, is that confidentiality, data security, and privilege are all already regulated for some entrants who are lawyers, but not others. And so, one of the key puzzles then is, okay, well, do we tolerate some lumpiness and do we tolerate some asymmetries, or do we level up or level down and ensure that a common set of requirements or a common set of constraints apply to all entrants to the sandbox? And so that's the first piece that the memo tries to walk through. But the memo also, I think, helpfully breaks the situations that we might think about into three concrete ones. And one would be voluntary disclosure. So that's a scenario in which a sandbox entrant wants to share some client or consumer data outside the representation. There's involuntary disclosure, and of course that goes to hacks and breaches and cybersecurity type concerns. And then there's also compelled disclosure. So would a privilege attach in a legal proceeding where someone is trying to pierce the what would normally be the attorney-client privilege? And so that's by way of motivation. I think I did a too long version of that the last time we were together. But if you then go to the end of the memo, we walk through three possible approaches that one could apply within each of those silos, voluntary disclosure, involuntary disclosure, and compelled disclosure. And so maybe having said that and having already talked too long at our last meeting, maybe I'll turn it over to Kevin, and maybe Kevin, you could walk through what some of our intuitions might be, or at the least put some concrete proposals out on the table.
All right, I think that one possibility is just to say that any participant in the sandbox adheres to all the rules to which an attorney is bound. And that would be the duty of confidentiality. It would also be the availability of the attorney-client privilege for any client-lawyer communication. That arguably would be the easiest approach, but then practical considerations would involve the fact that you might not have a trained lawyer who is trained in protecting the confidential information. Another practical consideration realistically is that no privilege can be created except by the legislature. So we have to make sure that the legislature would be on board to create the privilege. As for the duty of confidentiality, I guess that regardless of how we go elsewhere, my leaning from my experience working with California lawyers, being a California lawyer myself and being involved in state bar committees for nearly a quarter of a century, and the recognition of how valuable and important confidentiality and privilege are viewed in California, is that we apply the same approach to everyone. Now, there might be some wiggle room, and that would be a situation where you might allow, for example, the sale of anonymized data. That's somewhat perilous in the sense that there are instances where a third party can actually identify who your client is if you give out too much information. And the question is, would we be comfortable doing that? Because we have discussed in the past that under certain circumstances, the ability to make certain types of legal services affordable may depend on the ability of the provider to bring in another stream of income, which might be the sale of confidential information. But I guess I'm very concerned. And I'll give you one other example that I could see happening if we don't have the same confidentiality rules for these other providers. And if I'm a lawyer competing in the marketplace, I'm just going to put on my advertisements, by the way, they don't have a duty to keep your information confidential, and the courts are going to be able to order it disclosed. The other side's going to be able to get at whatever you tell them. Why don't you want to hire a lawyer? We practice law the old-fashioned way, not this newfounded way. So I think if we're going to, and maybe this will sound paternalistic, but if you're going to make these types of services attractive to the public, you might want to impose the same level of confidentiality. On the other hand, the argument I think is going to be, well, shouldn't the client be able to make that decision, to make that informed decision with sufficient disclosure made by the provider?
Okay. All right. So let me ask one, this spins off what might have been a throwaway comment by David at the last meeting, which was just simply prohibit commercial, non-client serving use of confidential information. Do you want to, that may have been just a thought balloon, David, but if you want to surface that now, it might be a good idea.
Sure. So yeah, I did say that I was actually leaning towards just a flat ban on commercialization of data. I think I still believe that, but I would love to hear what other people think. I think these are tough questions. Maybe one way to think about it is try to think about what the benefits of permitting some degree of commercialization would be, and then what some of the costs or concerns would be. On the benefit side, the reason to permit commercialization of data is that it might actually allow for certain business models that might not otherwise exist to flourish within the sandbox. So you can think of commercialization, the fact that a provider can get a small revenue stream from that data could actually permit it to provide services to disadvantaged populations that it couldn't otherwise. And, so if this group thinks that a main purpose of the sandbox should be to provide services to not just folks with general unmet civil justice needs, but folks that we could call truly needy or truly disadvantaged, then there might be reason to license a certain amount of, well, frankly, to license a certain amount of licensing of data and sale of data within the system. What's the concern? Well, privacy among them. You can anonymize data, but very powerful computer systems can often break through anonymization. There's a concept called differential privacy, and I'm glad to talk more about that. But you would worry that even anonymized data or badly anonymized data is not truly anonymized. And so that both brings complexities, because we would have to decide what we think truly anonymous data is, or at least the, whatever regulatory entity we create would probably need to police that in some sense. But then there's also always just the concern beyond that you're actually breaching privacy. You're breaching confidentiality, even though you don't think that you are. And so I don't know, Tom, is that what you're hoping for by way of some comment?
Yeah. The other thing, let me ask one other question. In your memo, you guys speak to this potential danger where we have a sandbox entity. They have a bunch of information, which they then, from individuals, which they then use to predict, presumably, the behavior of other individuals in the future, and that might conceivably be regarded as commercial use of individuals' data. It strikes me that we should facilitate that kind of use of data, but I turn to you, at least initially, David, and then to Kevin, in terms of whether that's a big deal, a small deal, and if it's something we need to worry about, how would we address it?
Yeah, that's another really big question. I think it's worth more thinking, even for me, I'm not suggesting that I have anything like a full answer to that. I do think that a provider's ongoing use of data to tailor its services should probably be seen as a positive. That can be seen as inherent in the idea of an automated system in particular, or at least a partially automated system, that you would want that provider to continually use the data to refine the services that it's providing to clients and consumers. And so it would be a little strange in that light to bar that kind of use. And Kevin can tell me if I'm wrong about this. On legal ethics matters, I am a country lawyer compared to him, but I think that information that, say, a law firm picks up pursuant to representation, it's kind of assumed that that's going to be deployed implicitly, for sure, in future representations provided by that law firm. Now, not in a way that can breach confidentiality, not in a way that can be adverse to the interests of the previous client, but it's just assumed that adds to the store of professional knowledge that law firm has and can then provide and make available to clients. So let me stop there and turn it over to Kevin.
Kevin, thoughts?
Yeah, to use an analogy, when I was many moons ago, when I worked in a law firm, if I had a particular issue that I hadn't yet addressed, I would usually be handed a memo. Today, I suppose you could just tell someone to search the database, the firm database, or the firm network to find, just use a few search terms and find it. But I'd be handed a memo, and it would be something within the law firm. As long as you're a lawyer, you can discuss other clients' cases they can assist you in delivering legal services to a new client. So as David mentioned, I think this was a discussion we had in ADLS. The technologists advised us that, yeah, we can use that data to help improve our programs, any sort of automation. That should be okay without violating confidentiality. It's not going to be revealed outside the entity itself. And one of the issues, I guess, one of the issues I guess we have is, and this would apply even to non-lawyers who work in a law firm. What happens when they leave the law firm? Do they have these same duties? And, or do we impose a duty on any new law firm where the person goes to that they cannot pick the brains of that person who may have picked up information? But as far as I think the use of client confidential information to improve and the value of your product, your legal services product that you're making available to the public, I don't see as much of a problem with that, so long as there are guidelines in place to ensure it doesn't go outside the organization itself.
Okay, holding that policy thought that this may be okay, how would we effectuate that against the background of the rules if it's not a traditional law firm? It's, I don't know, Legal Tech Inc., and they want to use the experience they had with clients 1 through N to improve the services they provide to clients ABC. Do we need to change the rules, or?
I'm not sure we would, because I'm not sure that I guess I'd probably want to know a little bit more as to the details as to how the entity intends to utilize the client information they previously have obtained to improve their program or their automated interactive product with any new clients that come by. Offhand, I'm not sure I see how that would disclose the identity of any particular client, where you just have it to improve the general operation of the legal services product that you have available on offer to the public. So I'm not sure there's anything more that would need to be done under the circumstances, other than the assurance that it's not going outside the figurative walls of the entity.
So Tom, if I can say something, I think this is a very much an indirect answer to your question, but I do think it's an important consideration here. I think if we're not in favor of a flat ban on commercialization, then there's probably still real virtue in a leveling up approach in which we would say that Rule 1.6 applies to any entrant, whatever its whatever its identity, right? Whether it would normally be subjected or would have to comply to those rules or not. And I think there's the virtue is, of course, that a lot of what's going to happen in the coming years is kind of uncharted territory. And there are a lot of law firms. There are a lot of big law firms, tech forward big law firms that are already quite self-consciously moving what they do along a spectrum from services to products. They're trying to think about ways to monetize, frankly, their expertise that isn't just the provision of bespoke legal services to individual clients. They're trying to think about products. The result is that we're probably going to get a common law fashion evolution of some Rule 1.6 interpretations that will cover some of these situations. And if you level up and you apply 1.6 to all entrants to the sandbox, you for sure put the obligation on a bunch of non-lawyers to stay abreast of those things. But that's precisely the point. What you get then is the dynamic adaptation of 1.6 over time as we enter this currently uncharted digital future where maybe we're going to see both like very conventional legal services providers using data in interesting ways. And if a sandbox eventually goes into place in California, we're going to see some non-lawyer legal services providers who are using data in interesting ways. And so you get that, you hitch then the regime to that evolving body of ethical law or ethical rules.
Okay, let me ask a different question. my role here is to zig and zag. Okay, this may not be quite the right group, but what if we were to level up, which is obviously the safest bet here, what effect should we, if any, should we be concerned about with respect to number and kind and quality of entrance into the sandbox? I mean, is this a killer decision for the tech-based folks that might want to enter into the California sandbox, or as long as we can get the statutes fixed and all that sort of stuff and make it happen, it's not going to be a problem? David, do you want to start, and then if others have thoughts?
That's a huge empirical question. So, depending on how we scope the sandbox, you're going to have some for-profit providers who are going to come into the sandbox. You're going to have some nonprofit providers who come into the sandbox. And say if you permit commercialization of data, you might get some providers who kind of sit somewhere in between, who are providing services to folks with very little ability to pay and are then using their commercialization of that data, hopefully in confidentiality respecting privacy regarding ways, but they're taking those revenue streams to be able to provide those services in the first place. And so it's an empirical question, like how many providers would fit into those different buckets? The full-on for-profit providers probably have independent business models that don't depend on commercialization. The nonprofit providers, they don't have a plausible business model no matter what. And small amounts of revenue from data isn't going to change that. That doesn't mean they're not going to come into the sandbox. I'm not saying that there won't be entrants. There may be lots of them. But then it's an empirical question, how many are in the middle? And this just makes a really important point here, which is part of the goal of a sandbox is to generate answers to empirical questions like this one. And we just don't know. You can lose a lot of money making bets on technology's trajectory. And so, I guess I would be careful about thinking about rules up front based on our own intuitions as to what the terrain of technology-based legal services providers is going to look like, certainly 5 years from now, maybe 5 weeks from now.
Okay, so let me ask a different question.
Could I throw in one other
Oh yeah, Kevin, go.
factor that something that we've been discussing reminded me of some of the ADLS discussions that we had. What we've been talking about, I think we've been focusing primarily on an entity that is providing what we've referred to as client-facing services. But there are also entities that might not just provide client-facing services, but might sell their product to other, lawyers and so forth to utilize. And so the question becomes, I'm not sure, earlier I said, as long as it doesn't go outside the walls. Well, if the product goes outside the walls, we just want to make sure that the product, they might have used confidential information in order to develop and improve the product. But once it goes outside the walls, can there be any backtracking to identify who might have been involved in the development of it? That's the only comment I wanted to make, just as an additional one that we should also take into consideration.
That's a point well taken. But let me, in the role of zigging and zagging here. So if we were, instead of leveling up, if we leveled down, using the CCPA, et cetera, what do we lose? What are the things that, or what are the dangers that we may be inviting into the sandbox, if any? And maybe to you initially, Kevin, and then back to David.
Well, from past experience, when we have, when we've had comments on our rules from the legal services folks, there's always a concern that's raised that they don't want to be secondhand lawyers, second class lawyers who are providing second-class services to their clients. I know that when back in the early 2000s, when we were exploring the possibility of carving out an exception for government lawyers to whistleblow on improper actions, illegal actions by a political appointee or one of their supervisors. We just had most of the government lawyers who came to speak to us were adamant that they didn't want to be viewed as second-class lawyers. So the question, I think one of the issues you have to ask is it okay to provide legal services that might not be up to the same level as David has referred to, the bespoke legal services, the one-on-one type of legal services that, we've been trained, people in my generation anyway, were trained to provide. That was the way to go about doing that. Is it okay to maybe take back a little bit of the protections? Because I think if we level down, then you have to consider, as you're leveling down, then on this seesaw, you're losing some of the protections that would apply with attorney-client privilege, because you can waive the privilege. And therefore, that information is going to be available, whether it's going to be available to the other side, it'll be available to the other court, it'll be available to the world under those circumstances. So that, I see, would be the major danger, the two major dangers, is the loss of the protections that we have traditionally viewed in the legal profession as encouraging candor in our clients to disclose the information that we as lawyers require in order to effectively represent our clients. And the other problem is just, will the services that are being provided be viewed as second-class services? And I'll pass it over to David, who can speak to other issues.
Let me ask a follow-up question, because it strikes me, if lawyers qua lawyers have all these things they've got to worry about, and it's super secret under various doctrines, that strikes me as potentially a competitive advantage to them as providers of legal services, and potentially creates a disadvantage to the non-lawyer providers. Is that something we should be worried about, do you think?
That's what I mentioned before, where I said, if I were a lawyer and we had, the sandbox was leveled down, then I would want to point out in my advertisements, and there'd be nothing wrong, it would be accurate.
Yeah,
I practice law the old-fashioned way. I have to keep your secrets. California lawyers have the strongest confidentiality duty in the country. I mean, we're unlike any other jurisdiction. And I would use that, and I would hit hard in all my advertisements if I were in direct competition with an entity that doesn't have the same duties that I have.
So, working along that same line, are we creating a disadvantage to non-lawyer entities by not doing the level up strategy?
It's possible. I think Toby had something to say.
Okay, why don't we go to David and then to Toby. David?
I'll just say three really quick things about the possibility of relaxing the CCPA as to some entrants, which I think was like the really focused version of the question. And
the level down.
Or level down. Sorry. So the CCPA applies to a very narrow slice of entities. I think that's first to note. So it may be that not so much turns on this, just because those are big entities. They already have to comply with it. We might expect that they're going to come into the sandbox whether or not they get a little relaxation of CCPA as to their actions within the sandbox. So that's the first thing I would say. I think it's worth noting too that if we want to relax the CCPA, that would probably require legislative approval, and that just might add additional transaction costs to this whole process in ways that we don't want to broach. The last thing I'll say is these are all really unformed bodies of law. The CCPA has produced some litigation, but as you probably know, there are always constitutional standing questions in data breach cases, and so for a variety of reasons, you haven't gotten a lot of evolution of the law. There's also a new version of it coming in as a result of the most, maybe not the most recent election, but in any event, there is, there was a statewide, one of the California referendums on this. And so we're getting a new version of it. And that's only on the CCPA side of things. On Rule 1.6, on the Rule 1.6 side of things, for instance, like that, the questions of how 1.6 applies to data and to data systems and data infrastructure within law firms, like that's still very much in evolution or in process as well. And so, it could be that you look up in 3 or 4 years and 1.6 looks a lot like the CCPA. It could be stronger, it could be weaker,
Well,
some approximation of it. And so maybe that counsels in favor of not thinking too hard about this, but rather making some kind of a principled decision and just assuming that we may be surprised down the road.
Toby?
Yeah, I guess what goes through my mind as I'm hearing this whole discussion is that the purpose of the sandbox is to allow people to try out things that are different. So that if we're saying, okay, people in the sandbox don't have to meet the same criteria as regular lawyers, that's the whole point of the sandbox. And whether it's confidentiality or investment or fee sharing, that's all part of where we go with this. Where I think it's important to go back to is that whatever those differences are, I think the rules are going to have to require clear disclosure to clients.
Oh, yeah.
So that clients don't think they're getting the same thing they're getting from a bespoke lawyer. That if there are changes in the rules of confidentiality or privilege, that has to be clearly disclosed up front and not just in a click through, consent, but clearly explained. So that's sort of the balance I'm trying to see here. My inclination is to go with the go up, everything goes up and on the confidentiality questions. Obviously not on the 5.4 questions, but on 1.6 and on privilege, I would want to see it go up just because I think that those are so critical particularly in California, where we've taken that as holy writ, if you will, that everything is confidential. But just one last quick thought, and that is, if we do decide to have a change in privilege, or if we want to move privilege up, the legislature has shown a willingness in the past to create new privileges where that was appropriate, when they relatively recently did that with lawyer referral services. So they created a privilege that says that whatever you tell the lawyer referral service about your case is privileged. So it can be done, and my inclination would be to go that direction.
Okay. And then, Patricia, if I can put you on the spot, I mean, you've been listening to lawyers geeking out here about rules, et cetera, et cetera. Do you have any reactions one way or the other? I mean, if you were asked to level up or level down, do you have a perspective, at least at a high level?
Hi, can you hear me?
Yeah.
You're asking me, right? I misheard.
Yeah, for sure.
I think that they should level up. I think the level up, absolutely. Thank you for asking.
Yeah, no, I mean, you're the only civilian in this conversation at this point, other than so. Yeah, that's very helpful. Thank you. Okay.
Thank you.
So this is a straw vote. We're not voting yet, but level up. I think I'm hearing Kevin, Patricia, David, and Toby going in that direction. Is that kind of a fair perception here?
Is it okay if I just jump in? Because I'm trying to get a sense if I'm correct in my understanding of the concept of level up. And so this is kind of responsive to a few things Kevin mentioned, Toby mentioned earlier, but when I was sort of understanding the level up, level down alternatives, it was really for what I understood to be the default or the ground rules for entry into the sandbox. And so what the level up would do is that it would affirm the duty of confidentiality, for example, for all attorney providers, and it would extend it to any non-attorney provider. And that's the ground rule for entering into the sandbox. But I always thought that, the purpose of the sandbox, as Toby was describing, was to encourage experimentation and innovation. So you can accept those ground rules going in, but then your specific proposal in your application would, for example, possibly be like what you have in the Utah sandbox. And so Utah, in their innovation manual section 4 under consumer disclosure requirements, actually contemplates a situation where the provider is offering a service model that might not be protected by privilege or confidentiality. And the Utah manual gives you a template disclosure. I think it says something like, this is not a law firm. This law firm is owned by non-lawyers. Some of the people who own or manage this company are not lawyers. This means that some services or protections like the attorney-client privilege may be different from those you could get from a law firm. And so again, my understanding of the level up concept was that it sets a baseline for when you're entering into the sandbox, but when you turn your attention to the specific delivery system that you're proposing, you're not bound by what has been leveled up as the baseline. You can actually seek to modify that if all of the risk factors fall into place and you convince the regulator that that's okay. And you would probably have to do a disclosure similar to what the Utah Innovation Manual contemplates.
I think that's certainly a fair description of Utah, but I think Kevin would say you've got to meet the standards that apply to lawyers across the board. That can't be waived. But Kevin, I can't speak for you. Do you want to just speak?
And I'm just curious as to whether I don't think Utah has done anything in terms of establishing a privilege for sandbox entities that are providing legal services. I think that would have to be done ahead of time, which might be why they have those disclosures where you have an entity. And I don't know how many entities there are. When I went through the applications a few months ago, it seemed most of them have lawyer involvement, but I imagine that there are some that don't have any lawyer involvement, and there would be, if that were true, then there would not be any privilege. So, I guess it's one thing that we should ask. I'm not sure as what you mean, Randy, by when you say as a condition of entry, you accept confidentiality, but then as you develop your business model or application, you can argue for something less, or what we've been discussing or describing as leveling down. And I think it's a policy decision on our parts, in our recommendations as to whether we think it's a good idea to permit a leveling down under the circumstances. That's really where I'm coming from. And you say sandbox, well, let's see how it flies. And I'm not sure, I'd be concerned about the disclosures. My contracts class right now, we're going over all the Uber technology cases, some of which were the courts approved and found out that the riders had entered into a contract with Uber. Others where they didn't, and therefore they didn't have to submit their dispute to arbitration because the terms of services link wasn't in the proper place. Those are things that I would be really concerned about, given how we have treated lawyers in California and the sanctity of the lawyer-client relationship and confidentiality. And I don't think I'm overstating the proposition when I refer to it as the sanctity of confidentiality, that we would do it. And yes, we can say, yeah, it can be client consent, but I would want a more robust disclosure and ensure that before a person can actually consent after receiving the disclosure, they have actually read it and that they fully understand what the potential consequences are. But we can talk about that, but it sounds like this would be something that would be a good discussion for the entire committee and not just our subcommittee. I'd be also curious to know the position of Becky and Tom on this, even though you are our fearless leaders.
I'll flip it to Becky, then you'll get me. Yeah, go ahead.
I mean, I'm I'm learning a lot from listening to you, and I'm obviously, if David is a country lawyer about some of these rules, I'm a country mule about some of these rules. So, I know that I know when I bump into them or something, but I think as a consumer and then as somebody who studies ordinary people, the tension I see is one between creating a market with enough diversity that the choices could be accessible, and maybe a lack of some of these protections might make something more accessible, or there may be kinds of problems where the lack of the protection doesn't matter, right? So is the disclosure ever going to be compelled in certain kinds of situations? And so I'm not really at that much risk as a consumer. So it's balancing that with, when you look at the empirical studies of disclosures, people are terrible at noticing them, reading them, understanding them, and applying them to their decisions. And
Oh
so
my
it's
God,
kind of
yeah.
it's sort of how much do you want to leave to their choice, our choice, my choice, and how much do you want to restrict up front? And I honestly I don't know my own answer to that question right now.
Yeah, I think, at least for me, I think I like leveling up, at least with respect to specific rules. I think that should be a minimum entry requirement. That said, if we had to fall back, it would require really a very significant, very clear disclosure. People get totally confused, and I think all of us blast through those disclosures that are made when you buy a new piece of software or download an app. You have no idea you're signing up for arbitration or all kinds of crazy stuff. We, I think, need to make sure that people understand what it is that's happening to them. That strikes me as a minimum. But I'm with, I think, Patricia on this one. I think I'm a level up kind of guy. But that said, to you, Kevin, Toby mentioned specific rules. What specific rules would be part of your level up idea? Which ones? Because there are several of them mentioned here. All of them?
I'd start, I think, with all of them, and then try and identify the rules, which I apologize. I had a list. I went through all our rules and I tried to identify some of the rules which might be subject to relaxation. And for the most part, the ones I came, 5.4 is a good example. That deals with the sharing legal fees with non-lawyers. It also deals with the aspects of the independent professional judgment of lawyers and whether they're being directed in their decisions, their legal decisions, by someone who might be a non-lawyer. That includes the prohibition on firm ownership. But I just remember when I went through, there weren't a lot of rules that I saw were of the kind that might be subject to, I hate using the word relaxing. I kind of like, let's use leveling down or something. Let me just give an example from the Utah applications. There was one where it was a multidisciplinary practice situation where you're going to have accountants, economists, social workers, lawyers, financial advisors, all in the same firm. And what they wanted to do is to reduce the application of the conflicts of interest rules between and among the different professions within the law firm. And I remember the application was approved without them actually designing what the rules for conflicts were going to be for that particular entity in the Sandbox. I think it may have been done. I looked at this like 3 or 4 months ago, and I think that subsequently they amended the application or the order that approved it. So yeah, I think conflicts rules could be something that we would permit to be done where we're satisfied that there would not be any extreme disloyalty to a client between or among the different providers within the firm.
Let me loop back, because I think on the table is whether we would, in leveling up with respect to confidentiality, require the application of rules 1.1, 1.6, and 1.9. Is that the focus? I don't want to take away from a future conversation about conflicts, et cetera, but are those the things we think we want to apply to all entrants if we take the level up strategy approach?
1.1 is competence. 1.6 is confidentiality owed to a current client. 1.9, confidentiality owed to a former client. There would be one addition. I think I mentioned it last time that I missed when we were drafting the memo. 1.18, which is duty to a prospective client. So if you have a person who prospectively comes in and discusses a matter with you, then you should still owe that person a duty of confidentiality. You shouldn't just be a honey trap for unknowing legal consumers to come in and disclose information to you that you would then be able to, I guess the word is monetize or commercialize down the road. So
Right.
yeah.
And
so as far as if we're just going to be talking about, if we're going to limit ourselves to privacy and confidentiality, which is what this discussion is about, those are the rules that we would be looking at to level up.
Perfect. And then one question with respect to 1.1, which is obviously the competency rule. You and David appeared to focus properly, I think, on competence to protect information properly and avoid breaches and things of that nature. So it's those essentially comments on 1.1, not whatever the rule of competency is that applies to lawyers more generally. It's that part of it. Am I correct?
Yeah, it's the competent protection of client confidential information.
Okay, that's what I thought. Okay, and then I think Toby, I zipped past you there, and then to David. Toby.
Yeah, I was just, we can pass because I was going to deal with some of the stuff Kevin was getting into and with all the other rules.
Yeah, we're on confidentiality here.
Yeah, I know the other committee has a whole memo on that they've got laid out.
To you, David, thoughts?
I guess I would like to speak for a moment to Randy's idea that entry might not involve imposing these obligations, on the entrance to the sandbox, but that we might want to permit, waivers on some sort of going forward basis. I wonder about that. I think that is loading an awful lot of responsibility onto the regulatory entity that's going to preside over this sandbox. I think we're going to face those questions as we continue on with this design process, and just how much technical capacity do we think this entity is going to have? My own view, which I think made relatively plain at various times, is that we need a good and robust entity, because I think we should be thinking about the entity's ability to police consumer harm on an ongoing basis, and therefore to preside over exit or ouster of sandbox entrance. And if we do that, then we can be less concerned with front-end entry. And I see that as a great way to serve the innovation and information producing benefits of a sandbox. I worry if we have an ongoing waiver system where we're asking the regulatory entity to take a relatively open sandbox and scrutinize providers as they're providing legal services for consumer harm. I worry about loading on top of that a waiver system where they're going to have to make very difficult technical questions about which relaxations, sorry, I know you don't like that term, Kevin, but which relaxations of confidentiality might be okay, and which commercializations of data might be okay. Again, that's an awful lot of burden. And then I'll just swing back and close by saying, this is what I like about leveling up and hitching 1.6 and 1.1, et cetera. These are, these are evolving bodies of rules, and they are going to have glosses put on them, and they're going to have interpretations put on them. And by leveling up, it's fairly simple. It doesn't put any ongoing, I guess it puts fewer ongoing burdens on the regulatory entity. And then we get the benefit of the adaptation that will no doubt happen as this system transitions into a digital world.
All right. Further discussion, because I think what may make some sense here is to ask for a motion.
I think Neil has a comment. Neil has his hand up.
Randy, go.
I think Neil has his hand up.
Oh, I'm so sorry. Neil, go.
That's okay. Yeah. No, I mean, I was just going to make a suggestion that I think the CCPA belongs in a different category. It's obviously has different intentions behind the law, and more importantly, this is a law that applies to everybody. It's the other branch of government's created this law, so to waive it would require their buy-in, right? So maybe an idea I had is maybe split off the CCPA in terms of our discussion here, and put on the other box the rules of professional conduct. The other suggestion I had vis-a-vis the rules of professional conduct is that you could say that you could say that right now those rules are so important that we're going to flag them. So if an applicant is saying that, listen, I think I need a waiver of one of these rules, that would trigger sort of a risk matrix that would say, okay, this is higher risk than the waiver of other rules of professional conduct. So just ideas, additional ideas to think about.
Okay. All right. Do you have a sense? I mean, I'd appreciate your just sort of horseback view of this. I mean, we've got leveling up protection that's kind of across the board. We know what we're doing, more or less. Possibly simplifies administration versus leveling down. Do you have if you were voting, what would you do?
From my perspective, it's really hard to say, because I can't foresee, and a couple of people have brought up this point before, I can't foresee what kind of applications we'll see, right? And what kind of innovations we might see. We might see something like and we'll look at it and go, oh my God, of course, Rule 1.6 shouldn't apply here, but technically it does, right?
Mm-hmm.
And so I don't have a good sense yet. I'd actually love to see maybe some examples out of Utah in terms of applicants there, whether they have asked for waivers of similar rules for professional conduct and why. So in a way, I almost feel like, since we do have at least a small database in Utah, and maybe now in Arizona, maybe it requires further deep dive to see what they're doing there and what models are coming out of there. Because I think last time I checked, I think there's like over 20 folks that have been actually admitted into the Utah Sandbox.
Yeah, there's about 25, I think now.
Sorry, 25. Okay.
Yeah. I mean, I think they're all pretty new into that system, but okay. What about this? I mean, I am perceiving a fairly significant support for a level up, and the level up being 1.1 with respect to the duty to protect the confidentiality of information from hacks, 1.6 and 1.9 and 1.18. So my sense is we're kind of there, but I can certainly, if folks want to sort of approve this idea provisionally, subject to maybe getting a little more insight from Utah and or Arizona, I'd be open to that too. But I to the extent we're comfortable making a decision today, that's the best course. So any to Kevin and then David, thoughts on that one way or t'other?
I'm not sure what you're asking at this point. I apologize.
Well, okay, let me, I think your proposal for going up is with respect to those 4 rules as described. Would you be open to getting approval of that today, subject to further insights, a la what Neil was suggesting, from Utah and or Arizona?
That's good. Are you inviting a motion?
Well, I just want to get a sense. I want to turn to David. Does that work for you too? Or do you think?
I think that's consistent with my view. I think those 4 rules, a leveling up approach, makes sense. I also think it makes sense to bracket and leave aside the CCPA. And you know, not to open a can of worms, I know we've had a little bit of conversation about this, but I might also bracket the attorney-client privilege and not include that, both for a bunch of reasons. I think both substantive and kind of political, or maybe not supposed to talk about political considerations, but that would require legislative action in the same way that doing anything to the CCPA would certainly relaxing the CCPA as to some entrants would require legislative action. So I think I'm in favor of leveling up as to 4 rules and setting aside the other 2 pieces of this.
Okay, Toby? Yeah.
I would agree with that, but I would make sure that they're set aside openly and not just not mentioned, but sort of, as you said, bracketed or yellowed on CCPA and privilege.
Got it. And so, Toby, the idea there would be that entrants would understand that if they come into the sandbox already subject to CCPA under its terms, then they continue to be subject to it. And then similarly, lawyer entrants to the sandbox are still covered or cloaked by the attorney-client privilege.
And the potential that as we go forward, we may want to look at revisiting, expanding privilege and or CCPA type coverage.
Yeah, and my operating assumption is, given that privilege is statutory in California, extending this is going to sandbox entities. The level up requires a statutory change. Okay.
Yeah, could I just,
Please, yeah, Kevin.
I'd like to add one more rule. It's
Another rule.
1.8.2, which goes to the use of confidential information of a current client. I should add that. And just to get all those city lawyers out there who know more about ethics than even I do, you might want to throw in Business and Professions Code 6068E as an Edward, because that's where the duty of confidentiality resides in California. It's in a statute.
B&P.
Yeah, Business and Professions Code 6068E.
So can I ask a quick question as the person who doesn't understand what you're talking about? And then I'm going to bounce it to Justice Tucker, who's had her hand up for a little while. So then the proposal is entrants to the sandbox are going to, whether they're lawyers or not, have the same duties of confidentiality, competence, etc. And
Right.
that means that I, as a client, have the same protections I would have as if I were working with a lawyer. And this also is going to 100% preclude any commercial use of any information about me that I share with the entity. Is that where this goes? Or is that last part not necessary?
Are you sharing within the entity or going outside? In other words,
You're taking data from 2,000 people and realizing that actually 98% of them face exactly the same situation. And so you could create a commodified product that then you market based on that information, for example.
yeah, I think the discussion we had earlier was that would probably be okay, because that was when David was talking about the big law firms that were using their information in order to create products for the delivery of legal services, not just providing the one-on-one tailored legal services.
Yeah, OREC and some others are really powerhouses in that area. But Justice Tudor, thoughts?
Thank you. I understand and agree with the idea that we not try to change the applicability of the CCPA. Either it applies to you or it doesn't, based on the way that law is written, not based on anything in the sandbox. But I am confused by the attempt to put the attorney-client privilege into the same bucket. It seems to me if we're going to level up as to duties of confidentiality, and I feel quite supportive of that, sounds like almost consensus view, that the attorney-client privilege kind of goes with that. And I realize that because it's statutory, it would require legislative action to make that happen. But the whole sandbox is going to require legislative action to make that happen. Right. So I don't think I don't see that as politically prohibitive, the fact that it would require legislative action. So if there's somebody who thinks that we ought to have a different rule for attorney-client privilege, I would like to understand better why. As opposed to just the general rule that you level up, that is to say, if you're a non-lawyer, but you're a Sandbox approved entity, you have attorney-client privilege, or your clients have attorney-client privilege protection, even though you're a non-lawyer.
I think it's the other way around. I think it's because the statute only applies to attorneys, in that the amendment might actually have to go in the other direction to say it actually also applies to these non-lawyers.
Oh, yeah, you definitely need to do that. Yeah.
Yeah, that's exactly what I'm saying, that in authorizing the Sandbox, we would ask that the legislature would authorize an extension of the attorney-client privilege that currently applies only to lawyers, and that they would extend that privilege to apply to any Sandbox approved entity, even for its non-lawyer providers.
Right.
Okay, so I'm not sure, Kevin, were you the one that sort of thought we should segregate out attorney-client, or was
I don't think I made that suggestion.
Okay. All right, let's tee this up for a vote. David, would you make a motion? I thought you kind of covered all of the bases that or captured all the various points in the conversation. Would you mind making a motion?
Sure. And so are we in agreement then that we're going to level up as to attorney-client privilege as well?
I think yes. This is my, yeah, okay. Include that in your motion.
So,
Make it voted down. Yeah.
Can I just ask one quick question, which is that maybe this goes to Kevin and Toby, who, this is kind of in their bailiwick. But would that in any way impair scrutiny of consumer harm by non-lawyer legal services providers?
Say that again?
Would that in any way impair scrutiny of non-lawyer, if we did level up, if the attorney-client privilege applied in full across all entrants to the Sandbox, would that in any way impair, say, the regulatory entity's ability or anyone's ability to scrutinize the operation of those services providers and perhaps try to gauge the extent of consumer harm?
Well, one thing, if I could jump in, one thing we haven't talked about yet, but I'm sort of assuming, which is that as part of establishing a Sandbox, we would also ask the legislature to establish a very limited exception to the attorney-client privilege to apply to attorneys and non-attorneys who are active in the Sandbox, to allow the Sandbox regulator to scrutinize the activities of the Sandbox participants, even though the attorney-client privilege might, under other circumstances, not allow that.
Yeah,
I was going to pass that question on to our experts from the state bar and the disciplinary system, who would have better insights as to what information might be available when a lawyer is subject to disciplinary proceedings.
Well, in the state, in our office, anytime a complaining witness complains to us about a attorney's conduct or performance, that initial complaint waives the privilege. So, and sometimes we have respondents say, oh, there's a privilege applies, and we cite the rules of procedure for the state bar that allow us to ask the questions and them to share information about their performance. So it's all in our rules.
But I think Justice Tucker's point was an excellent one, because, right, Mia, you may also want to explain sort of what the state bar has. It is more difficult for the state bar to investigate a complaint where the client does not come to us, because then, in order to get the information from the attorney, they honestly and correctly say, I can't share that information. That would be breaking the attorney-client privilege. So I think Justice Tucker's point is spot on.
Yeah.
Right. And in those situations, just to add, if we have state bar investigations or other complaints that we open on our own to investigate, and we may need to interview or contact a witness, we have to do non-complaining witness waivers for that. And there's a process that we go through for for that within our office internally. And sometimes we do reach out to complaining witnesses and they don't want to talk to us. So there is a different process for that, for sure.
Yeah, I mean, it strikes me just, being able to do spot audits and things of that nature. I mean, it seems to me that should be at least potentially part of the regulator's toolkit, in which case, I think Justice Tucker's point really hits that right on the head, it seems to me. But
I was
okay.
going to jump in there too, real quick, Tom, and just
Yeah, Bridget, go.
With the proactive regulation approach that we're also thinking about taking here, I think it's really important that we build that into the recommendations and to hopefully statutory amendments, because we don't want to wait for somebody to complain, I think, in order to make sure that we're properly monitoring what's going on in the sandbox. So I do think that's very important.
I think that makes sense. Have we may have knocked you off the trolley tracks there, David, but would you start again and make a motion that includes this limited waiver or scoping of the attorney-client privilege in this space, so that will allow for regulatory review, and then make your motion about the various rules?
Can you say that again? What was the first part of that? Because I was ready to make a motion about the rules, but then you added something else in there, Tom.
Well, I was thinking that part of this would involve getting a statutory exemption from the attorney-client privilege as it may apply to a sandbox entity that would allow for regulatory review and oversight by the sandbox.
Well, why don't we do two separate motions then? Can we do that, or is that just needless?
Oh, let's do that. Okay.
Okay. So I would move that we recommend that rules 1.6, 1.1b, 1.9, 1.18, 1.8.2, and the attorney-client privilege, and we could add in section 6068E, since that's technically where some of those rules reside, that those apply in their then current interpretation to all entrants to the sandbox, not just entrants to the sandbox who would otherwise be covered by those rules.
Okay, hold that thought. Mimi, I think, did you get all of that?
I'm trying. Hold on. Give me that.
Okay.
I hate to be like the idiot today, but David, could you translate each of those rules into one noun that says what it governs?
Well, 1.6 governs confidentiality. 1.1b governs duty of competence. 1.9 is information from a past representation. 1.18 is a prospective client, and 1.8.2 is a current client, right? So each of those.
Prospective client is 1.18.
Sorry?
1.18 for prospective client.
Oh, what did I say? I'm sorry.
1.8. It's okay.
Oh gosh. Okay. Yeah. 1.18 applies to a prospective client, or applies to information regarding a prospective client.
And just so one clarification. So with respect to the duty of competency, it's competence to protect information, right? It's not the broad duty of competence and all that it carries with it, correct?
Yes.
Okay.
And then
All right.
6068E is really the heart of confidentiality, because if you look at 1.6 just says you can't violate 6068E.
Right.
Okay. I think that makes sense. I mean, Justice Tucker's point that we're going to need legislation here anyway. This is all good. Okay. Is there any friendly amendments, any understandings we need to?
Question of clarification, because Becky previously mentioned the issue of commercialization and how that all works with all of this. And maybe this is a question for the ethicist, but with regard to commercialization, if you're, right now today, you're outside of the sandbox, you're a lawyer or a law firm, and you wanted to commercialize your client's information, that would likely be a business transaction or an adverse pecuniary or financial interest governed by Rule 1.8.1. And if you go through all the hoops, you could do it.
Right.
If you're in the sandbox, does what we are contemplating in terms of voting on right now, would that be more of an absolute ban on commercialization, I guess is my question. Because it sounds like normal ethics analysis outside of the sandbox would let you do it if you go through the hoops.
Yeah, let me defer to Kevin, but I think the right answer is the rule is the rule, and whatever you can do, you can do. But Kevin, what are your thoughts on that?
Well, 1.8.1, you're saying if it's not a business transaction with the client, is it? If you're commercializing your client's information.
Well, if you have a, say, a technology-driven delivery system where you are using a person and you're in a contract or strategic alliance with the actual vendor of the technology, and the product that they're creating requires them to collect data from lots of other law firms in order for that predictive validity of that AI to work. I mean, we had, Joshua Walker on ADLS, who was the spokesperson for, for things to work, you need big data. And so the idea that a law firm or a sandbox provider might need to get some sort of agreement that I kind of have to sell, if you will, or transact transaction with the tech provider to feed your information. And you can go talk to another lawyer under 1.8.1. The terms and conditions would be it's going to be anonymized to the best of our ability, but we're actually going to give that to the provider as part of our deal with them for helping us build the technology. And they're going to be building similar technology using the same information for a lot of other lawyers or law firms as well. But it's theoretically permitted under 1.8.1 to be able to do things that would otherwise be adverse interest to clients if you go through that rule. And I think the commercialized use of their information, when you're talking about using it for big data and tech-driven delivery systems, we might not want to have an absolute ban on that if it might stifle that type of innovation. But that's just a question, because I know we were talking in broad strokes about how 606AD or 1.6 or 1.8.2 would be a complete shield protecting that information so that it couldn't be commercialized. But my thought was, outside of the sandbox, I think a lawyer would have an argument under 1.8.1 that they could do it.
Yeah, but I think, the moving party here is David, but I think the no commercialization rule is not part of this motion. It's basically these rules and their standards apply to sandbox entities. Is that your sense, David?
That was my motion. And so I threw in a little bit of legalese. I said the then current interpretation of the rules, because as I've noted earlier in this meeting, we don't know what that digital future holds. We don't know whether some of those firms who are moving along that spectrum from services to products are going to be using data in this way and generating interpretations of 1.6 or other rules that either permit or don't permit certain practices. So I think that's implicit in the hitching idea, which is we would be, by leveling up in this way, we would be hitching all sandbox entrants to however the interpretations of those rules evolve over time.
That's fine. Unless there are proposed friendly amendments, I'm going to ask for a second.
So quick question, Tom.
Yes.
I may have lost the thread here, but when David went through the motion, I didn't hear him say the CCPA, and I thought that was still part of the discussion. So I just wanted to put that out there.
I think that was in a bracket, but David, thoughts?
I did not mention the CCPA, but I realize now that with actually I think Toby mentioned this earlier, that we should expressly say that maybe I should extend my motion. Am I allowed to do that under parliamentary rules? Which is that the sandbox entrants who would ordinarily be subject to the CCPA will continue to be subject to the CCPA, and that will be made clear to them upon entrance to the sandbox.
Okay. Just scrivening here. Mimi, did you get all of that?
Yeah, I think so. Hold on, give me 1 second.
Oh, bless you. You're my heroine for the day. Okay.
Am I too fast a talker as a motion maker?
No, we're okay. I think I'll read it back to you. I might not have caught the very end, but I think it's okay. The motion is to recommend that rules 1.1b, 1.6, 1.8.2, 1.18, and 1.9 as well as Business and Professions Code 6068E will apply the then current interpretation of the rules / statutes to all entrants to the sandbox. And then there was a, and not just entrance to something, but I guess it could be okay with just all entrants, period.
As the rules are currently interpreted.
Oh, I will apply the rules and statutes as currently interpreted. Okay.
What or just could we say would apply in their then current interpretation? I worry that something that says currently interpreted makes it sound like it's at the moment of the motion.
Yeah. Then currently. Yeah. No, absolutely.
Will apply in their then currently.
No, then current interpretation.
Current, yeah. Okay.
Current.
Thank you very much, David. I need a second.
Second.
All right. Any further discussion? Going once, going twice. Mimi, let's do a vote.
And we're adding also at the end of that motion, and Sandbox participants who are ordinarily under CCPA would still be under CCPA.
Yes, and that's consistent, Toby. Okay.
Can I ask a question clarifying?
Please.
And this circles us back to the point Randy made earlier about leveling up, but then allowing exceptions. Are we, if we approve David's motion, saying there will be no commercialization by any sandbox entrants of data, and that these rules we've just enumerated cannot be waived by anyone? Or are we simply saying that they're going to apply to everyone unless and until, and in the unusual, I assume, circumstance where the sandbox regulator decides in an application to waive them?
I believe the current motion is they apply, could not be waived. This is a minimum standard, is my sense. But David, is that your?
Yeah, that's right. On the second part, on the second thing that you said, Justice Tucker, I don't. My motion does not include a waiver process once admitted to the sandbox. On the first, though, as to whether this is a motion that embodies a flat ban on commercialization, I do not think so, because of course what we're doing is we're hitching sandbox rules to those rules as they may develop over time. And it could be that those rules interpret in a way that permit a law firm or another legal services provider to gain consent from clients to commercialize their data, or to otherwise commercialize their data in confidentiality preserving and privacy preserving ways that therefore don't breach the rules.
And if I could just make one quick
Kevin,
point.
go. And then back to Justice Tucker if she wants time. Yeah. Kevin, go.
Rule 1.6, Rule 1.82, and Rule 1.9 all contain provisions that say an exception is client consent, informed client consent. So you can always obtain client consent to utilize the information.
And I think that's another place where we're hitching, because what constitutes authentic consent and what does not is going to evolve. And there are surely, I think they've already been articulated during this meeting, there's surely concerns about, click wrap agreements and the things that I think Tom said we all blow through. And so I think, here again, we're hitching the rules to however that broader body of interpretations evolve over time.
Okay, any further discussion?
Patricia?
Yeah, oh, Patricia, please.
Hi, so I have a question. I got a little lost. So say I'm a legal student and I would like to conduct a study on how this sandbox facilitated access to justice. And so I want to do a preparatory for research, getting the information to see if the study is even a valid study to have. Then they go through the human subject office, the ethics board of their university to get permission. Does what we're proposing allow for that to happen? Or are we saying that because of the term commercialization, I started to get a little bit lost, but if that preparatory for research is going to publish a paper that says, this was impactful in X, Y, Z, and then and then we move on to the next phase, which is that publication stimulates interest from AI groups in technology to start doing data pools, then I think my understanding is that we're talking about the second step of data pools for AI groups, for example, in technology. But are we also covering that portion where people want to do research on the sandbox and the fact that it helps, or hopefully it helps people? Is that covered?
Yeah, David or Kevin, do you guys want to cover that one?
So if Patricia, you're asking whether non-commercial use or research use of client confidential information would be permitted.
Yeah, research use, yes.
Yeah, and I think that could also, we could rely on the disclosure provisions of the confidentiality rules that would permit that.
Okay. Is that responsive? All right. Anything further? Because I think it's time for a vote. Mimi, go ahead and do the roll call.
Okay. Tom Green,
Aye.
Becky Sandifer,
Yes.
Martha Alkenbrock, Judge Irma Asbury, David Freeman Engstrom,
Yes.
Micah Star Liberty, Kevin Moore,
Yes.
Toby Rothschild,
Yes.
Patricia Scutiero.
Yes.
Thank you.
All right. Excellent. Bravo, guys. And major kudos to David and Kevin. You guys are rock stars. Thank you very much. And this brings us back to Becky and her part, another part of the agenda for her.
Were we going to do a second motion, or are we going to set that aside?
Oh, for the Privacy Act, yeah.
Oh, yes, excuse me. Please make a motion and we'll zip that through.
I'm not sure the motion was about the CCPA. I believe the motion was to give some voice to Justice Tucker's notion that this regulatory entity that is set up to preside over the sandbox would need some ability to pierce the privilege as it might apply to sandbox entrants in order to perform the regulatory scrutiny that it is tasked with performing.
Yes, I think that's a correct description. Is that sufficient for a motion? What do you guys think? I think it is. Can I have a second?
I would just make sure we add confidentiality and not just privilege, and then I would second it.
Okay. Is that okay with you, David?
Sure. Yes,
Okay.
absolutely.
Discussion? Going once, going twice? Mimi, would you call the roll?
Sure. Hold on. So the motion is to recommend that that the regulatory entity have some type of legislative, I don't know what the word was that you guys used earlier, but be able to pierce the confidentiality and privilege in order to regulate the sandbox participants.
Yeah.
That's great. I like that.
Okay.
Yeah, nice.
Tom Green,
Yes, aye.
Becky Sandifer,
1,000 times yes.
Martha Alkenbrock, Judge Irma Asbury, David Engstrom,
Yes.
Micah Star Liberty, Kevin Moore,
Yes.
Toby Rothschild,
Yes.
and Patricia Scutiero.
Yes.
Thank you.
Thanks, guys. Now over to Becky.
Okay, that was awesome. We've all done a lot of work today, and this is great. And now we're going to do even more. This is to me, this is like the most exciting part of this project, which is to get to envision its parameters. It's also a really challenging part of this project because there are a lot of things that go into thinking about those parameters. And so today, there's Dreamworld, and Dreamworld would be we get to a point where we might be in a place where we could make a proposal about substance, not anything else, or at least partial substance, to the group for the September 17th meeting. And we may not make it that far, and that's okay. But that's where we're going, because the kinds of decisions or recommendations that we make today shape a lot of everything else that we need to do, both in this group and any other group. And I just want to sort of, when I think about what scope is going to affect, so we've talked about it as in or out or open or closed or whatever, but I mean, you're talking about who can be a client of these entities in the sandbox. You're talking about who can make money from things that happen in the sandbox and how. You're talking about what areas of law, so securities or landlord tenant or whatever, people can receive services in, or entities, organizations can receive services in. You're talking about who could be in charge, who can manage and run these things. You're talking about who could deliver the services in these things, and you're talking about the types of services that can be offered. We've already just made a scope recommendation by saying, if you can't level up, you can't come in, right? So that's already a boundary on this activity. But I mean, so these are really core questions that we need to work through, and they're going to be really consequential for what can come out of the other side of the sandbox. David has written a really interesting and thoughtful memo that I hope you all had a chance to take a look at. It's dated from January, because David was prophetic and thinking about the issues that would be on the agenda for today. I think it's probably actually a typo, but these things happen. And so now I'm going to turn it over to David to kind of open up the discussion on, I think, these really interesting and needy and also challenging issues.
Okay, thanks, Becky. I put in a memo, and I did so with trepidation because I didn't want it to read as some kind of an affront to our fearless co-chairs or to various staff who have helped keep us moving in the right direction and work on agendas and that sort of thing. But I basically said two things in the memo. One was that I thought that we should, as a group, try to de-emphasize wordsmithing a mission statement, and instead start thinking more concretely about what some of the actual scope provisions would look like. And there are a couple reasons for that. One is that, as I put in the memo, maybe this is the second main point I made in the memo, there doesn't seem to be a textual warrant in our charter or our charge for trying to limit the sandbox to needy or disadvantaged groups. Now, that doesn't mean we couldn't get there as a group necessarily, but I just didn't see a textual warrant. And so for that reason, I thought, let's not worry so much about the mission statement. There are going to be lots of folks with lots of views. There are lots of important design values that I think are going to go into that process, but that it might be more productive to move away from that wordsmithing exercise and instead try to think in more concrete ways about what the precise design provisions look like. Beyond that, I have a couple of ideas on what I think some of the decision principles should be as we do that hard compromise design focused work. But I think I might not try to voice those right now, and instead, I don't know, see how people react to the proposal that we push past wordsmithing and try to focus on those design principles, as well as the question of what our charge and our charter actually says.
Thanks, David. So there are different ways that we could start talking about this. We could call on Kevin because Kevin has something to say. Kevin.
Good idea.
He then muted himself.
Okay. I've been thinking a lot about this, and I see that we have two extremes. I shouldn't call them extremes because I don't view anybody on this working group as being an extreme person. I know many people are extreme, but I think we're all reasonable. We have certain views. And I've had my experience on the ADLS task force, where I had some people who pretty much were pushing for a Wild West approach to revising or amending the legal regulatory system, and other folks who, and I probably would put my camp in, I would be in that camp, who lean more toward regulation that is protective of the legal services consumer. Yet I'm trying to think of how can we come to a midpoint, which is going to be acceptable to everyone. And I thought back on something that I believe it was Judge Chang said at one of our first meetings that said, well, perhaps what the sandbox should be, it shouldn't be too restrictive openly, but we express what we're trying to do. Now, I know that the California gap study said all income levels. And I don't know what that means, all income levels. I'm not worried about whether Bill Gates or Elon Musk or, our friend Mr. Bezos can afford legal services. They can. I'm not worried about that group. I'm looking primarily at, we can talk about poverty level, 125% of poverty level, middle class, upper middle class, whatever those things mean. Yes, those folks have problems with access to legal service, and I'm fine with that. But, getting tied up too much with all income levels, I think we should be focusing, and I think we did this during the drafting of the mission statement back in April, we left it pretty open, that we should be focusing on individuals. And I know you say maybe not, that some of the innovation is going to come from providing legal services, innovative legal services to businesses, regardless of what their size might be. And maybe I'm willing to go in that direction. But I think that, before you get the imprimatur to go on, we have to see some movement of the needle. So I'm leaning in favor of going for a longer period of the sandbox, a 5 to 7 year term. I'm not quite where Andrew is, who wants a 20-year sandbox. I mean, the kids are going to grow up, they're going to be adults before the sandbox is ended. So my preference is, have a 5 to 7 year sandbox, but let it be known, what are we interested in? We'll let you play in the sandbox. We're really interested in innovation. But for permanent changes to the rules, where we're going to be evaluating changes to the rules, we got to see some movement in the delivery to individuals, those whether they be lower class or middle class. I think that might achieve the goals of the innovation folks who want to make the sandbox open to innovation, but at the same time, keep us focused on who are we trying, or, what should we be trying to accomplish? Because remember, we are the Closing the Justice Gap working group. Where is there a justice gap? Sure, we can get innovation. And I know you can talk about the iPhone, you can talk about automobiles and everything. I'm not willing to wait 20 or 30 or 40 years for those advances to happen. I want to see them happening sooner. And I want to put, goose those innovators to keep in mind that final approval, where you're going to be able to exit the sandbox and play with the big folks, is going to depend on whether collectively or you have contributed to the ability to advance the delivery of legal services to individuals, whether they be small businesses, and close the justice gap. Remember the justice gap study, they said all income levels. What did they focus on? They kept repeating throughout the report that they were focusing on those folks, low income people. That's what they were focusing on. So I'm a little bit concerned, but I really want to. I care a lot about this, and I'd really like to see us somehow get to a point where we can compromise. So maybe I haven't advanced it. Maybe I haven't talked generally enough for folks. I tried to suggest a concrete example. I don't think it's mine. I think it was pretty much what Judge Chang talked about early on in our discussions on this. And that's pretty much what I have to say.
Thanks, Kevin. That's very helpful. Just to make sure, so I'm going to restate what you said and make sure that I understand it. So this would be an idea that the sandbox at the entry point is open. And then when you're thinking about the rules to change and the things that would be authorized at the end of the 7 years, those would be things that spoke to the justice gap issues for people past the poverty level, up the income stream, and to small businesses. So where there's a known gap, which we know is more than just poor people, that would be part of the criteria for moving those models forward. Is that what you're saying?
That's what I'm trying to say. Yes, that I want to see some real advancement in closing those gaps. And if you open it up as much as you want, if you've had that, if we've been able to develop that, if the innovation has actually, I don't want to use the phrase trickle down, the Reagan years killed my enthusiasm for that term, but let's call it filter down. They might be saying the same thing, but if those innovations filter down, great. I'm perfectly willing to do that. But I think we can't just say, open up innovation, let 1,000 flowers bloom, and expect that that's going to happen. And we can wait 10, 20, or 30 years. There's a number of issues. I mean, with the rent moratorium, we can't do anything about that right now. I realize that. But these are things that are going to be happening. They're going to be happening quickly. And I don't want to wait a decade or two before we actually accomplish anything. And any ideas that people can come up with that are feasible to advance something in the near term is something that I'd be willing to get behind. Thank you.
Thank you. Donna.
Thanks, Becky. So I just because Kevin was asking specifically, what did the bar mean when they said when they were talking about the justice gap affecting all income levels. So since the justice gap study was developed by an office under my leadership, I thought I would just give a little context here. And I think part of what we struggle with is in the common parlance, when we talk about justice gap, I think we all think about low income. When we conducted the justice gap study, we were looking at, we were starting with that premise, frankly, and we were also basing the justice gap study on what was the study that was performed by the Legal Services Corporation, which focused entirely on 125% of poverty or below. And we were looking at, so we looked at that piece of it, but we actually sort of took it further and said, we want to see how far up the income scale the justice gap actually extends. And so the way we looked at it, we did a lot of focus on what are the findings for those at 125% or less of the federal poverty level. I think the way the survey was organized, it didn't sort of break it down into the what did you say, the Bill Gates people? It did, but it said 200%, 300% for, I think it went as high as 600 or 700% of federal poverty level, which is about a 180,000 for a family of four, I think, if I did my math correctly. But we did look up, and it could be sort of anything above that 600 or 700% of the federal poverty level. So that study was concluding that up the income scale, as far as the survey was concerned, there was a gap between the need for legal services and the access to legal services. And so I just wanted to sort of make that clarifying point. I don't know that says anything one way or the other about every other point that Kevin made. I just wanted to provide that context.
Thank you.
Thank you. Could I just ask one clarifying point from Donna? And that is, there are two gaps. One is the affordability gap, and there was an information gap. Yep. That the report recognized. And yes. Are we looking at both, or are we primarily looking at the affordability gap?
Yeah, that's a great question. I mean, I think there are other avenues that the bar is exploring to address what we refer to as that knowledge gap. I don't even recognize that as a legal problem. So it may not be that the sandbox is going to get at that. I was going to say fully, may not get at it at all. If there are innovations that somebody wanted to bring to the sandbox about how to make people aware that a problem is a legal problem that could have a legal solution, I think the more that we are able to tackle that knowledge gap from every perspective we can, the better it is.
Thank you both. Tom?
Yeah, just a point on just on this question of at all income levels. I think it's very important for us to put that in context, because that little bit of text arguably supports the idea that we could do a Bill Gates centric system of deregulation, and that's what the bar had in mind. I'm not sure that that's actually true. Actually, where I fall is where I think David fell, which is we've got a fair amount of discretion here, and I think we need to be really practical about this. But to the point of whether or not we need to move the needle for low and moderate income people, I think from my perspective, that's an absolute requirement. And again, to put this in context, obviously the name of this thing is the Justice Gap Task Force. It's not the Law Deregulation Task Force. It's focused on a gap, which was identified in various reports. And even more specifically, when the Board of Governors voted on our charter, the staff document says this advances a specific goal of the board, which was support access to legal services for low and moderate income Californians, and so on. So I think, and then even the language itself, consumer facing technology that provides legal advice and services directly to clients at all income levels. One can imagine, say, a technology based solution which might well serve poor people as well as rich people, or upper middle class people doing wills or something. That language does not mean that we don't need to address the gap, which is largely a low income, moderate income problem. So I think from my perspective, it's a practical one. If you focus all of your work on people that don't have any money, the business model is going to be a little nonsensical, frankly. I mean, you need to have some people that are going to pay so that you can provide these services. There has to be a source of funds. So I think we should be thinking about innovations that really provide, maybe it goes up, into higher income levels, but ultimately and quickly begins to provide assistance to folks at the low and moderate income level. I mean, I think that really would be a real advance for California. It would be a real innovation that would, I think, facilitate focusing and advancing this cause of addressing these low income problems. Because these are just hideous problems. I mean, when you look at the numbers, I mean, the number of folks that have no representation in family law court, geez Louise, we got to do something about this. I mean, we can't, assume that because of a little smidge of text that talks about a specific kind of innovation that may be applicable to various income levels, that somehow we don't have to worry about this. The problem is the real problem that we've got to solve. So that was my thought.
Thanks, Tom. Folks have other thoughts? Toby.
Yeah, a couple of things that came to me as I was listening here. I agree with Kevin's approach of, let's make sure that by the time this ends, if it's going to go forward, that it has to show that benefit. I would maybe add a little more, and that is something that would provide a preference up front, not an absolute, but a preference in consideration for those that can define how it will accomplish that. I think we talk about small business. I think we need to define that because the federal definition clearly goes beyond what I consider small business. When I see, multi-million-dollar businesses with, 500 employees constitute small business. I think we need maybe a different term that would identify the kinds of businesses, looking at mom and pop kind of businesses, not, significant corporations. On the source of funds questions for the people aimed at low income, I think you got to remember some of these innovations may come from organizations that have other kinds of funding. I can see a legal services program that gets LSC funding, IOLTA funding, grants from foundations and stuff, developing a software or whatever that will help their efficiency by bending or softening some of the rules or adapting somehow. It's not just 5.4 that we're talking about. And I have one more note and I can't read my handwriting. Yeah, the problem with, the courts are so overloaded and we've got all these people who can't afford it. I think we've got to recognize we're not going to solve that problem totally. That what really we need to look at, and not this task force, but some other one, is changing the system. Maybe there's other ways than the current court system and legal system to resolve some disputes that might, make that easier. So we can't look at that as the end point of our work or the goal.
Thank you. This is kind of going in a direction, but do folks have other things they want to say at this point before we try to draw lines around the direction? Neil.
Yeah, I was just going to say, to sort of maybe go back in the direction of David's point of view, not trying to wordsmith it too much. I mean, the way I see this is that it's simple. It's three things. One, it's to foster innovation. Two, it's to make legal services more affordable. And three, it's for regulatory reform. And within regulatory reform, we're considering, mitigating the risk of harm, those issues. And I think that's the gist of it. And when you talk about affordability of legal services, that talks about affordability at all levels, all incomes, right? And that gives the parameters of what we're trying to do here. And I don't know if we need to say more than that. But just to go back in the other direction, those are my thoughts.
Thank you. Andrew.
Excuse my video not being on. I'm having challenges with my internet connection today. I just want to raise something additional to think about. Not that we need more to think about, but and follow up to Neil's comment. And this is where I've been focused on from the beginning and trying to help the group consider this quote. What do we want the sandbox to do? And I think we're getting a little distracted when we consider the income level of those folks we wish to serve, because the sandbox, and I think it's clear in the board item, is to create a safe environment to test the existing rules and regulations. And if that is to make permanent changes at the end, you can gather data to say permanent changes can be made to a handful of rules and statutes. If that is the goal of the sandbox, then so long as the applicant can meet all the requirements that we've already been discussing and are agreed upon, it shouldn't, in my view, it shouldn't matter what the income level is of the potential consumer, because the more people that come in the sandbox, the more data you can gather and the more informed decision we will be able to make as to what revisions to make to existing rules and laws at the end of the sandbox. And I think that goes along with Neil's point. I hope so. That's my intent. He listed three things. One of them was regulatory reform at the end. And I would agree with that.
Thank you. Tom, your hand is still up.
Yeah, actually, I did want to add just a smidge more. I think that part of, the bar's resolution speaks in terms of public protection. So I think sort of a variety of thoughts, but I think we don't want to create second-class services here. So I think that it's very important that the Sandbox at least do a preliminary look at the effectiveness and the efficacy of the business models. I mean, the problem here is that this is not a market in which it's not like wheat, it's not like corn. People don't know what they're buying, they don't know what they're getting. This is not a situation in which regulation might be inappropriate. So I think the bar or this Sandbox entity needs to step in to make sure we understand that the thing that is being offered is efficacious, that it actually works. I mean, we've talked in terms of the idea of competence. I think of it as efficacy. There are some contract kinds of terms. There are implied warranties when you buy a thing. You know, it's good for the purpose that you talk to the people about. It's merchantable. It will do what ordinary things in that market do. But I think basic efficacy review and providing a guarantor that what people are going to get is not a flim flam. I think that's a very important aspect of what the Sandbox does.
Thank you. Do folks have other? Toby, yeah.
Yeah, I just following up. I think what I heard Andrew say, and it troubled me a little. Neil talked about the 3 goals: innovation and regulatory reform and closing the gap, making law more affordable. We've got to remember those are ands, not ors. And we're not looking, we can't say, well, this helps regulatory reform, so it's okay. It has to help regulatory reform and be innovative and help address the justice gap. That's all.
Thank you. Kevin.
Yes, I wanted to make the same comment that Toby just made as well. And I really want to emphasize that we shouldn't get too far ahead of ourselves on regulatory reform. And I'm a rules guy. You know, I love amending, drafting rules and amending them, or at least suggesting amendments, even if the Supreme Court doesn't agree. But this is the kind of stuff I enjoy doing. But that's not the end in itself. I view, the idea that, okay, fine. Yeah, the rules work. And we have a lot of businesses who are making lots of money. The clients who they are serving are being protective, but darn, none of the clients are the people who really needed help in closing the justice gap. So I think, we cannot advance one of those 3 goals: innovation, regulatory reform, closing the justice gap, over anything. They are so intertwined. And I think we need to have all 3 before we go ahead and approve things at the end when all is said and done. Now, I know that Andrew, I see has his hand up, and I'm not criticizing. It's just that I just wanted to make the emphasis of how interrelated all 3 of these aspects are and are going to continue to be. And I'm not criticizing Andrew in the least.
Thank you, Andrew. Andrew, are you there?
Yes, I'm here. I apologize. At the outset, I made a comment trying to help reach agreement. I didn't mean for my comment to create further distraction. I don't disagree with anything Toby or Kevin are saying. I apologize if my focus on the regulatory reform was the takeaway. What I meant by that was that would be the purpose of the Sandbox, would be to create a safe environment in order to evaluate whether or not rules and laws can ultimately be changed. And I wholeheartedly agree. And I meant, as part of why I was chiming in after Neil, that the other 2 components would obviously be taken into consideration with that. So I'm not intending to be a distraction. I was trying to focus part of the group's consideration of this is, what do we want the sandbox to do? And maybe others disagree with me. Always my understanding of the sandbox was to create a safe environment to test the.
We lost the end of your sentence.
But I think we got the message.
Yeah, and
Sorry,
Andrew,
Okay, thanks.
you got Toby and me to agree.
Okay, thank you.
So Becky, a minute ago, you said that you saw this moving in a direction. What direction do you see then?
So I'm hearing, if we're just thinking about like boundaries, that's all I'm focusing on. But the boundaries are there to achieve particular goals. I'm hearing a pretty open front end that might have some kind of incentive or preference or first processing rule for proposals that make a case that they can contribute particularly to the access goal of the 3 goals that have been identified here. But
You're cutting out. I think we lost Becky.
I'm still here.
Yeah, you were gone for a bit there.
I was gone for the part when I was trying to explain what I thought you were saying. Okay, so pretty open, but with some preferences for things that meet the access goals. But then once you're in, then you're thinking about exiting and also which specific rules to change and how. And the criteria of focus for exiting and which specific rules to change and how are making some appreciable, measurable, noticeable impact on access. That's what I'm hearing. Now, jump in and tell me what I'm missing or what you want to modify. You've all gone totally silent.
Okay, so I'll jump in and say, I don't disagree with the consensus as you just formulated it. I wonder whether we could add one specific point of consensus, which is that there should be no area of the law that sandbox entrants cannot practice in. Because I'm not hearing any suggestion that there should be, and that would be a concrete specific rule that would be helpful. And if, for example, that is what we intend and decide, then in our application, we might add under that long list of areas of the law, an extra one that says other, please explain, to make clear that, hey, not just these listed ones, but any area of the law is potentially eligible for sandbox participation.
The other thing I'm not hearing any upfront lines drawn about is the sort of the corporate structure of the entity. So I'm not hearing anything about the degree of external investment or how fee sharing would work, or that hasn't come up. And it may not have come up because we were much more focused on access and but first of all, if we're comfortable with what I described with Allison's amendment, are we comfortable with that as sort of the way everyone's feeling right now? Okay, so that's something.
Oh, wait, that's
That's
time
a
out.
lot.
That's a
Yeah.
huge step. I think you need to at least put that in a bracket. I mean, amongst other things, when the ATOLS group offered actually a pretty diminished version of alternate business structures, they were overwhelmed by criticism. I mean, this is a giant deal, and I think we need to, put that in more of a think about it kind of mode. And
What's
at
the
least have
this
a
that's a
more fulsome
giant deal?
discussion. ABS is a giant deal.
Gotcha.
And so in other words, the principles that Becky articulated first and then the principle that I articulated second are important and helpful. But the point that Becky just came back to and said, I don't hear any restrictions on what the ABS should be or what the non-lawyer ownership should be. That's just because we haven't talked about it yet. And maybe.
Well, yeah, I think that's right. I mean,
Yeah.
we got to get this through various decision-making bodies and not least the big group. The first few things that the two of you articulated, not that controversial, sounds pretty good. But as soon as you get to the basic structure, that ABS thing is just a lightning rod. And I think we have to be, cognizant of that as a political and policy lightning rod. So.
And I think we probably need to have some concerted focus on that issue. So for
yes,
example,
I agree with that completely. Yeah.
We may want to have some restrictions, and maybe we ought to think about alternatives and look at what some other jurisdictions have done and discuss them. And maybe this is the place to come back to where David at the beginning of this discussion said, I have some ideas about what some restrictions should be, but I don't want to surface them yet. I don't know, David, whether you might feel free to start surfacing some of them now that we've gone a little further through our discussion.
Could I just ask for clarification? And I'm not sure what the second aspect that you brought up, Justice Tucker, did you say not to limit the areas of law in which participants can practice? Because what we've been discussing up to this point, I thought, as we're going through the application, is that we're trying to, there was the Utah, but I remember very well from our discussion on the ADLS task force that what we wanted to do is focus on those areas of law which the justice gap study identified as the ones where there was the greatest need. And I understand the pushes and pulls there, that on the one hand, innovation might demand a little bit more openness in the types of areas that it's available in terms of the remuneration that can be realized. On the other hand, we have the particular areas that were identified where the need is greatest in the gap study. So I'm just wondering whether we should discuss that more, at least keep it as something that's open for our discussion at the larger group when we meet on the 17th.
You're right about what I meant by my point, or by the second point. And I thought I was channeling what might be a sense of the group. And what you're saying is, no, not so fast. Actually, that's very much a contested issue. Yeah, potentially contested. And so that's helpful to know. And I don't know whether that's where this group wants to go next, or whether we should just bracket that as a still unresolved issue.
Yeah, and I realized it was probably a reasonable inference from what I had said earlier, that that's what I intended, but I guess having it explicitly voiced as you did, I'm a little bit hesitant to go all in right now.
Got it.
Thank you.
Yeah, I don't know that we've given enough thought to that to really be able to reach that conclusion in the 8 minutes that's left.
When I was hearing you talk about it, I was thinking both along the income levels, but also, when you were talking about what kind of preferences you would want to give,
yeah.
You could give preferences to those practice areas that were identified in the justice gap study, just like you would give preference to the types of individuals you want to be serving. But that, the similar concept, it would still be open to other things with the preference to those things that were identified in the justice cap. That's how I was interpreting your conversation earlier.
I'm guessing it wasn't how I was interpreting myself as I was talking.
Thank you all. David, did you want to enter in here?
Sure. So, when I first spoke on this topic, I said I'd had some decision principles in mind, and I think they've been voiced in large part, and maybe voiced in better ways than I'll be able to voice them. But let me go forward anyway. I think it's, I personally am wary of prescriptive rules in this space. So prescriptive, like front end rules governing entry. And the main reason I think is just basic humility. I don't think we're going to be able to predict, and we can't predict ex ante where innovation is going to come from and where harm is going to present. And there are all sorts of questions, right? Will innovation come from and or will harm present in the nonprofit sector, in the for-profit sector? Will innovation come or will harm present in particular legal silos, so substantive legal silos? There's the filter down question, by the way, Kevin, I love that. I've been saying trickle down far too much, and filter down is just far better and avoids, that Reagan-esque third rail. So, but these are all like really important questions. And I think that we should be careful about putting into place prescriptive rules on the front end in light of that fact. And so then the question is, well, what instead? Like if it's not prescriptive rules, and here's where I think people have already started to articulate really good ideas. If it's not going to be prescriptive rules, and if we're certainly not going to get rid of front end scrutiny, but if there aren't going to be prescriptive rules that sort of hive off whole areas or types of providers or what have you, then the question is like, how can we move this experiment in a direction that gives some voice to some of the things that Tom was articulating? And the answer might be incentives. So it might be, a system of expedited processing. I think that's something Toby has mentioned maybe in past meetings. It might mean a tiered system of fees. Like if the nonprofit providers who come into the Sandbox are doing it because they can get foundation funding, we shouldn't be imposing onerous fees on them. We shouldn't have those scarce grants going at least in part to paying the fees. I could imagine having a tiered system of fees that has the for-profit sector subsidizing the nonprofit sector, and therefore gives the regulatory entity enough resources to do the kind of work we want it to do. I could even imagine different stringencies of disclosure or scrutiny once in the Sandbox based on, which populations are being served. I mean, all these things are incentives that help move this very large project and experiment in directions that normatively we might agree with, without putting into place front end prescriptive rules that have built into them all kinds of assumptions about where we think innovation is going to come from or where harm is going to present. So that's one principle. A second principle, if I might, I think that information is one of the really important values we should be thinking about and thinking that this experiment will produce. And I think that if I can put a fine point on it, I think that consumer harm is both something that should be minimized wherever we can through wise design provisions, but it's also an empirical question to be tested. And I think there's going to be a lot of temptation, especially maybe as we go to the wider group or as we get closer to details of what all of this looks like, to really focus on minimizing consumer harm. But I really think we need to remember that consumer harm is both something to be minimized, but also raises basic empirical questions that this Sandbox is designed to test. And so again, I think innovation information should be just as much of a keystone as we think about what kinds of compromises can be struck or what sorts of provisions, design provisions, incentives, or something else should go into it. It should be just as important as as protecting against consumer harm. So I don't know. That was my effort at a couple of design principles. I would like to say that I would be glad to work along with others to try to hash out a proposal that would maybe have that would try to strike some of the balances that we've all talked about now in the meeting to this point, that would maybe try to, lean heavily on incentives rather than ex ante prescriptive rules. I'd be glad to, to serve on that sort of thing if anyone wanted to join me. I know, Tom, right at the beginning of this meeting, or at least when I joined after I finished teaching, you said that you can't strong arm people to do it, but they could volunteer to, to try their hand, something like that. And so I guess I'd just like to put myself forward if anyone thought that would be a good idea, or if anyone wanted to join me.
So thank you for that generous offer, David. I think my question to you and to the group, and I'm mindful of the time, is do you feel like you and who you might work with on this have enough information from this conversation to pose at least the rough outlines, or to pose the issues that we've surfaced? Do we have something to tell the group by the 17th? Or are we still thinking among ourselves?
Could I speak to that? Because
of course,
I think we're missing a couple, 3 people who are more in the narrow, in the group that wants to narrow the sandbox at the, at the application stage. And I'd like to hear from them first. And I'm just wondering whether there would be time, and I'm not sure how easily it would be to fashion this in a Zoom meeting, that we could have a breakout session of these subcommittees perhaps during the meeting, where we could come back and review it, or maybe we could wait until the meeting after this September meeting coming up before we come up with a final proposal. But I'd be a little bit hesitant. I'd like to hear from some of the other folks who are on our subcommittee before we go forward, and just get their insights, their input on what we have proposed, so far. I thought this was a great discussion that we've had. I've really enjoyed it, and it's really helped me put together my thoughts where I hadn't had before. And I found out that I got to be careful what I say, because it can be interpreted in unusual ways, reasonable ways, but not what I intended, perhaps.
Yeah, my apologies, everyone. Thank you very much for a great meeting. I've got another thing I've got to get to, but I really think this has been one of our most, if not our most productive meeting. I mean, we're starting to grasp the really tough issues here. I think this is very exciting. And to that point, if you create a subcommittee, Becky, I'd be more than pleased to volunteer as well. But thank you all. Have a great long weekend.
Wonderful. Thank you.
Take care, Tom.
Good weekend, Tom.
You too. Thanks.
So it sounds like at least David and Tom are willing to work on writing up something that reflects the conversation as far as it's gone today. It also sounds like the group wants to hold off on sharing that with the full group until we can get further input from the folks who aren't here today. I don't know when our next subcommittee meeting is. Does anyone know?
Give me 1 second, I'm looking.
It is October 8th.
October 8th, yeah.
Okay, that's about a month. So then, proposal, David and Tom and anyone else who wants to work on this particular part of our project works on that and then brings it back to that October 8th meeting? Or do we want to, is there some imperative to move faster than that through some other mechanism?
I'd be happy to lend my kibitzing skills to the drafting project.
Great.
So it'll be David, Kevin, and Tom.
Fantastic. Just
And
to
They're
review,
going to
will that
prepare a
group-
recommendation for the October 8th meeting, correct?
for the October 8th meeting of this
Got it.
subcommittee.
Yep.
And
got it.
in working up those recommendations, will that group look not only to channel what we have already discussed today, but some of the things we didn't get to discuss properly. For example, whether there should be a limit on areas of the law or simply a preference, and whether there should be any of various kinds of limits on the waiver of 5.4. For example, should we do something like what Florida is doing in requiring only active capital to be allowed to participate in non-lawyer ownership of firms? That's just one restriction, but I think there are some others that would sort of present themselves, which I realize are, David, unlike what you favor, they're prescriptive, potentially upfront prescriptive limits, but it would be, just certain kinds in the 5.4 area that I think somewhere we need as a group to be discussing in order to be doing our job right. And whether it happens as part of what you prepare for October 8th, or whether it happens in some other forum, I'm willing to be agnostic whether you want to take that on or not, but I do think it's something that we do need to take on and have people thinking about and presenting to the group. Hey, here are some options, and here's why we favor whichever one of them.
Great. Yes, Patricia.
Hi, and then what is the impact of active capital? Because I don't know that term. So if that could be defined, that would be helpful too. Thank you.
Great, thank you. So
Justice Tucker, I think we can do that. I think that I noted in the memo that I put in for this session that we should move away from wordsmithing and to think concretely. And so I see considering those things, even though we haven't had a chance to discuss them, as consistent with that. Like, let's try to come up with something concrete. I think we probably all do better as a group when we have concrete proposals in front of us. That was certainly, I hope, the case with the leveling up, leveling down discussion that we had during this meeting. If we have like a clear bullet pointed proposal, it gives something for, that people can grab hold of and chew on. And so if it's okay with everyone, I would gladly add the 5.4 active capital and the question of substantive legal silos. I would gladly include that in what we prepare for October 8th, just to lend concreteness to what we talk about.
And I will apologize to Patricia and say I just sort of made up that phrase, active capital. All I was trying to do is, without having the exact right words at my own fingertips, to say that there are proposals that say that only people who are actively involved in managing and participating in an enterprise should be able to invest capital, as opposed to, like hedge fund outside investors or something.
Okay, thank you for clarifying.
And when I use the term, I was just deferring to a fancy appellate judge.
Great, thank you.
So Bridget and I will Rochambeau to figure out who is lucky enough to provide to this esteemed group of volunteers whatever staff support you need on this new volunteer effort.
Yep.
You include me in that too. I'd like to be included in that. I assume we're only going to have to be able to work in writing rather than trying to set up a meeting because there's more than two people.
Can I just ask real quick before we go? The first, you raised a few different things, Becky, but the very first concept that you raised, which now I don't have in front of me, I'm just wondering if that could be presented to the group, or would you rather just wait and tell everything? I'm just wondering if maybe that overarching principle that you first articulated would be beneficial for the whole group to hear about and for us to have a discussion about.
So the idea that the front end is open, that you have the Toby Rothschild incentive and preference for potential entrants who can make a case that they're going to work on the justice gap. And then you have the Kevin Moore, it gets narrower, under the Moore principle, which is after 7 years, you're assessed for exit, and we make decisions about rule change based on whether what that activity is doing is making a dent in the justice gap.
Yeah, I don't know. What do you all think about that? I guess I was just thinking it would be nice to have, because I thought that was so well articulated during the meeting, and it was such a great discussion. I wonder if that would be helpful for the larger group. Sorry. Or we could just do it all at once. I don't want to like throw a wrench at the end of the meeting here, but I just was wondering if there's any aspect of this discussion that we could move forward.
I think it sounds as though some of the specifics about how the preference might work are still TBD for October. So it might be confusing or unproductive to do a little bit
That makes sense.
partial presentation for September.
And as I was saying that, I was remembering that you pointed out, Kevin, that some people were missing that may have a different view on that first point too. So sorry, forget I said that.
Could we just revisit the point that Toby just made about how many people can be communicating? I don't think it's just a meeting. I think it's by email as well. So if we do in the group communicate by email, we always have to make sure that we copy the CTJG email address, right? Is that accurate?
So that is accurate. And so, yes, the open meetings rules apply to email or in person because you are sort of coming to decisions. However, the difference here is this isn't sort of a formally appointed committee. This is, we've solicited a group of volunteers to put together an idea that's going to be presented to the committee. And so we can sort of there isn't a hard rule of two that applies to that, but we do need to make sure that we are not gathering together more than a quorum of the group, because then it very much crosses the line.
So we're cool with 4.
How big's the group?
It's 9. So
9, so you
should
couldn't
be
add
fine
any
with
more
4.
than this.
Yeah, you could have 4 and you guys could have a conference call. We do it with COPRAC as well. The drafting teams for each opinion do meet on the side, but as long as it doesn't exceed the quorum of the subcommittee, it should be okay.
Okay.
Good.
All right, wonderful. Here we are on a Friday afternoon before a holiday weekend, having had, in my opinion, the best meeting of this group ever. So thank you all for all of your hard work and all of your very thoughtful contributions to this conversation, which I think is going to move the ball for our subcommittee and for the broader group. So I hope that you have a wonderful weekend, and thank you very much. Take care, everybody.
Bye.
Thank you, Becky. Thanks so much, everybody.
Ditto.